Let us pray. Almighty God, we ask for your blessing and wisdom upon this parliament. Direct and prosper our proceedings to the peace and welfare of the people of Solomon Islands. We ask this in the name of our Lord and Savior Jesus Christ. Amen.
Thank you. Parliament is resumed.
Bills Committee stage, the Public Service Bill 2025.
Thank you. Before the committee resumes, let me just remind members that we have about 34 clauses more to go. My intention is that we must dispose of the bill, the third reading, that we devote afternoon to the special motion of adjournment that the Prime Minister wishes to table before Parliament is adjourned. So I'm just reminding that I want us to dispose of the committee stage and on to the third reading of the bill. Thank you. Okay, we are now in the Committee of the Whole. Now, as I just mentioned earlier, indeed yesterday we made very good progress. As I said, we've had 34 clauses to go, and let us continue where we had left off yesterday. On that note, I think we begin here this morning on the clause 103 of the bill. Does any member wish to comment on that clause before we take a vote on it? Clause 103. Any comments on that clause? Thank you, Honourable Leader of Opposition.
Thank you, Chairman and Bavag Salian. Sir, if you could come to 9:30, I think this time we will finish in 34 clauses here. The committee's recommendation 61 with regards to recognition, with regards to association, was also we discussed earlier, I think first the law committee, that you should no allow more association more, as was explained by the Honourable Attorney General. Associations registered under the Charitable Trusts Act. I mean, no one for purpose law act here now for what should rightly be trade unions, industrial relations associations to be registered under the Charitable Trusts Act. And I think it'd be tidier if we just say, no problem, you register under the Trade Union Act here now, so that there's only one gate for both recognition and dealing with labor relations within the public service. So I have now the recommendation number 61, sir. Minister, care to comment on why we are persisting with having associations under Charitable Trusts Act? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Officer of Opposition. In reference to associations here, all associations can be registered under the Charitable Act, and I think the Trade Dispute Act is also recognizing what associations. So, with regards to this bill here, IMI adaptive number one name or IMI aligning number one name the Trade Dispute Act IMI recognizing. So, as it is now, associations have been registered, most associations registered under the Charitable Act. Thank you, sir.
Honourable Minister, Honourable Leader.
Just on that point, perhaps the Attorney General could clarify to the committee the point where ministers say the Trade Unions Act, recognizing two associations registered under the Charitable Trust Act although earlier explanation below Attorney General was that no one for purpose law charitable trust, no, this one law labor relations matters. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question. As stated earlier, I think in the past there were a number of associations that had that sort of relationship with the charitable trust and sort of industrial action groups. However, as we go on, and since not far back no more, we have now made it clear that any associations under charitable act have only for those charitable purposes act and follow him along. If you were to go into industrial action, you will have your association deregistered and awesome. So it's only those specific purposes that charitable trusts act allow that you proceed. I gather that in the excuse me, in the Trade Unions Act, you can register certain groups, industrial actions group. So maybe if an association brought a company, like for example, now you can have a number of us under business name or like just a community company. So you say maybe for associations also come under that, or what would not commercial cooperative. If they are permitted, then to be registered as under a trade union act as a purpose for trade unions, then maybe we could allow that. But for now, if also in terms of specifically for trade unions and industrial action groups, you would have to only be registered under the Trade Unions Act. And so if it permits another association that can be recognized, then that's where it can come in. But if it does not, then by him hard for you have an association that is for industrial action, let me say. So I'm looking at, like for example, Government Lawyers Association. If that association on its own can be recognized under trade unions, then that can also be fall under this definition here. But if I'm requiring that association must be incorporated or registered under the Trade Unions Act, then it has to be that way before any recognition is given to it for that particular purpose. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. MP for East Jessel.
Thank you, Mr. Chairman. Yeah, part 11 is very important. It is about employment relations. I guess every good thing that is acting. I'm telling Mr. Chairman how the employees and employer deal with each other. Climax here. How you may deal with him, any fallout, or any understanding between employer and employee. There's a difference between trade unions and employee associations. I think we need to appreciate that big difference, Mr. Chairman. Trade unions got a very narrow focus, very narrow focus. What we look normal as collective bargaining, wages, benefits, and maybe working conditions, and also employee association, which is more favored and supposed to asking view anyone who look at the better arrangements between employer and employee association, employer and employees. it is to an employee association. Because I'm broad, very broad category, Mr. Chairman, and I'm including groups that focus on internal welfare, recreation, a lot of other things that make a relationship between employer and employee. I'm good. Not only when wage, when the wages increase, you strike now. And trade unions are supposed to be handling good, are capable of bringing down a country, supposed to be handling good, Mr. Chairman. I'm also saying so. I don't know the thinking here, Mr. Chairman. Maybe just a point to take note of, because the policy basis and how for arranging things and how the government want to relate with the public servants is taken here. And so the definition of employees association and minimum trade union under the Trade Unions Act kept 76. No really familiar with it as well, but I think it's really focused no more on wages. You fight for wages, you strike now. Employees association, as much as possible, we discourage them strike. It must not happen, because what the relationship I'm good all the way now. Any small something happen between employee and employee, with a quick time addressing. That's the spirit of employees association. Addressing quickly before I'm reaching the stage of strike. So just maybe a point to note, Mr. Chairman, if you ask anyone, a better arrangement between employer and employee is employee association. Mr. Chairman.
Thank you, Honourable MP for East Joseph. Honourable Attorney General.
Thank you, Mr. Chairman. Thank the MP for East Joseph for those remarks and also question too. So CPU is a registered trade union. I think these terms of also if we look at 105 recognition of employees association, it's just for the purpose of negotiating collective agreements. That's the key word in here. So inside, let's say inside law, government imigarem engineers association. So what like for under MID, for example. So we want to come together for negotiating just terms of conditions of employment. For the purpose of collective agreement scheme of service, that's okay. Him now and act to provide for. But when it comes to furthering it to a industrial action, then that's where you don't enjoy those rights as a trade union by himself enjoying. If Osamoto engineers here would want to go on a strike, they would have to come under umbrella of law, CPU, for example. But then CPU would be for everyone across the board. It wouldn't be just for that specific, niche group of elites or professionals, let me say. So that's where, when it comes to negotiating collective agreements, PS has that authority to recognize engineers association, but it's probably just a loose term more given to a group of engineers who group together for same engineer MID, like story within UPS. Same for lawyers too. Same for if what let's say inside of lawyers, criminal lawyers like negotiating or DPP level, for example. Those are the scenarios where you could employ this part law actor. But when it comes to industrial action, unfortunately, you must be registered under trade unions to enjoy the benefits and rights given to trade unions by law. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Honourable Leader of Opposition.
Excuse me. That explanation, I think, is a good one the delineation between an association, which plays this very important role where Member Blois Joyce Olhemi Talen, and then the role below trade union now. Association no go play more that role. But we have had in the past associations pretending to be trade unions, and that's why committee have recommended no more. For trade union matters, there's only one gate. And recognition law, trade unions too, only one gate no more. Not having associations masquerading as trade unions. You'll see in recommendation 64, the Bills Committee report, where we talk about clause 113 later on, when there should be an aspirational objective for Putumlo there. I'm aspirational only in nature, but for say, we work to avoid strikes, encouraging both employer and employees to resolve disputes through dialogue and cooperation, whilst preserving the legal right to strike where lawful conditions are met. So trying to hold that balance. So associations to look after, not just welfare, but also professional interests plus certain groups. But one have good something. But some of that welfare issue and rightly below trade union now too, yeah. So respecting that boundary is critical. The way it's worded here, and look also Tuvala are given equal definition when it comes to engagement in industrial action. And that one now was in Bills Committee, after a number of stakeholders raising, Bills Committee make that for a recommendation, and the two should not be equated when it comes to industrial action. Thank you, Chairman.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. When it comes to, industrial action, the only legislation whereby say give him your authority for the autonomy, trade unions. So, in terms of equal footing, that one, the other one wouldn't have that. Privilege. But also, just for illustrate more another example, law under police regulations. There's a police officers association regulation 2013, where him provide for whole association to for police for look after welfare about police and not families blocketa. So that's another association that is not under the Trade Unions Act, but also can be used for a collective agreement, negotiation for a collective agreement for this particular niche employees. Thank you, Mr.
Thank you, Honourable Attorney General. Honourable MP for his say-so.
Thank you, thank you very much. I think that one, with him with police here now, and become the arrangements for relationship between employer and employee, public servants and government by nice to us. Because no allow more for strike, Mr. Chairman. So I think the definitions, the definition of party, Mr. Chairman, will be each recognized association that represents in the negotiations. I think that is represented in the negotiation.
You're making reference to 103B.
Mr. Chairman, there's still clause 103, right? And it lists and defines a number of terms they claim. The other one term defined this party of a negotiation means B, each recognized association that represents in the negotiation. I think in terms of English structure, Mr. Speaker. I think ISNA must follow that, is represented. Asking Minister of Education.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Choice for that. Yeah, I think there's a word missing in there. By making correction, that can be corrected later. Attorney General, so we're doing that on under Legislation Act. Thank you very much. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Any further comments on that clause 103? Thank you, Honorable Chair of the AC and MP for Central Honiara.
Thank you, Chair. Just additional, how we can recognize the employee association. So we have problem in recognizing associations that are registered under the charitable trust, isn't it? So are there other legislative avenues in which association can be registered other than the charitable trust? So that you make clear in this one, because I think we should allow employees to register association. I mean, the experience that we have with CPU, for instance, was that I think at that time we had been advised to register association and get recognition under the Trade Union Act, like that. So it's a two process. One, registration of association, and a recognition under Trade Union. So that's how some of these unions, and then later they were called unions, but the association registered under the charitable trust, which later you may find out that Pepper's Law charitable trust here, ex-prisoners, something was saying, no, it's not for this purpose, OSEM. But that's the nearest that we could go to register an association. So are there any other legislation that can provide for the registration other than charitable trust? Thank you, Chair.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, all MP for Central Honiara and Chairman PAC for that question. Yes, there is other avenues. For one example, let me just give him earlier, was under the Police Act. There's a regulation that is made for police, actual term, Police Officers Association. And what I'm established for now is to bring issues relating to employment, conditions of service, occupational health, safety issues, and other workplace issues to the Commissioner, the Minister, and the national and provincial governments. Objects Law Association, and also go with for welfare services to police officers and their families. Also cover to sporting, educational, recreational services, activities for some police too. So that's one avenue. I think in the Narawan nurses, I think come under National Council. I'll have to check on that one, but could be that as well. But yeah, that's one example. No blow police. Yeah. Thank you.
Thank you, Honorable Attorney General, Chair PAC.
Yeah, Chair, so that's a very good explanation that AG will give Kamia. So can that be also done in terms of the public service employees that would want to establish their association and then get recognition under the trade union? If that is the case, then possibly under the regulation, we could provide for mechanism for them to actually establish their association so that you may not run into the troubles in what we have now with CPU, which is an association registered under the charitable trust, And then, of course, it is now, subject to so many interpretations as to it's a wrong avenue for registering non-national association. So maybe that's probably the way for remedying that situation, to have a provision in the regulation to allow for registration of association or establishment of association, where members of the CPU, the public service employees can actually choose to register their association and then have recognition under the Trade Union Act. Thank you, Shay. What would be your comment on that?
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. I think that can be done under the regulations law, public service bill. Minister may make regulations recognizing what are various associations inside the public service. But as a whole, as a trade union, I think public service, CPU, is registered under the Trade Union Act for that purpose. Other associations which am referred to in 103, which come law 105 law clause, it's basically, you may say, a permanent secretary can recognize an employee association for the purpose of negotiating collective agreements. And no only purpose will have no for negotiating. So if what are engineers like negotiating terms and conditions for within PS, they can. PS are recognizing every engineer's law, MID. At lawyers, if every lawyers come together, but then what a law DPP say, if a criminal lawyer deal with him, we need one for me for Seleva, and they want to negotiate with that law PS, then under this part they can do that. But as a whole law public service, that's where CPU will come in. But then that's the thing, these associations, they don't enjoy the privilege that trade unions have under the Trade Unions Act, which includes industrial action, or associations, collective associations, or by no survey enjoy na industrial action. Bis only law Trade Unions Act no more, if you put in, you like for strike, that will road no more, but you come here. Thank you, Mr. Chair.
Thank you, Honorable MP for Central Honiara.
So say for instance, over the other associations that are established in other legislative avenues here, would want to seek recognition under trade union. Is that possible? Is that possible that they get recognition under the Trade Unions Act, and therefore they are recognized as an association with a union of certain professionalism by order garden to pursue their common interest or collective interest? So they get recognition under the Trade Union Act and then apply for recognition under this legislation, for instance. Would that be an avenue that they can look for, or no more, or they have to stick to what is being proposed in this legislation? Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. Unfortunately, under this Public Service Act, I'm only for negotiating collective agreements no more. If you would want to go for industrial action, you must be registered. You must be a body registered under the Trade Unions Act. Each time you register under, you have a number of privileges. One, and also in Italian industrial action, you also enjoy immunity from certain things if you participate inside industrial actions. Whereas here, it doesn't afford you those privileges, which only you may recognize in trade unions now. So under Trade Unions Act, and strictly Italian too, unregistered trade unions do not enjoy the same privilege as registered trade unions under the Act. Thank you, Mr. Chairman.
Thank you. Any other comments, Honorable MP for East Are?
Thank you, Chair. Thank you, Minister and AG. Just on the negotiation, we're defining it here. I just wanted to know whether there's a definition also in the Trade Unions Act that defines negotiation there or no more? Thanks.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for East Harare, for that question. Under the Trade Unions Act, I'm looking at any definition of a negotiation.
Thank you, Honorable Attorney General. Any further comments on that clause? Otherwise, let me put the question. The question is that clause 103 stand part of the bill. Those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 103, therefore, stands part of the bill. Clause 104. Does any member wish to comment on this clause before I put the question? Clause 104. Thank you, Honorable MP for Central Honiara.
Thank you, sir. So where an employee's right, I think so in this law, an employee is not prevented from joining a trade union or other representative association. So perhaps, Law Minister Namo, so what you meant here is that, you know, there can be a dual rights that you can enjoy by being a member of either a trade union or a representative association. So would that be possible under this legislation? Thank you, sir.
Thank you, Honorable Minister.
Thank you, Chairman. Thank you, MP for Senator Honor and Chairman of the PAC. Yes, the intention is employees can join any unions or any associations. Yes.
Thank you, Honorable Minister. Honorable Chair, PAC.
So, Minister, so by himself, he can be a member of a trade union, at the same time can be a member of a representative association. And he will not get penalized by the employer for being a member of a trade union and a member of a representative association. So I'm now questioning, he can enjoy a dual right in this legislation, isn't it? Thank you.
Thank you, Honorable Attorney General. Sorry, Honorable Minister.
Thank you, Chairman. Yes, so the policy intention is that the employees can join unions and associations. So that's the policy intention. Thank you.
Thank you, Honorable Minister. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question and answer that. Yes, this is an example me give you. An engineer can be a member of CPU and also be a member of the Engineers Association inside government. So I'm saying to time like negotiate for the engineer, him good. Time like negotiate for the everyone under CPU, he can do that or she can do that. Thank you, Mr.
Honorable Attorney General. Any further comments? Honorable MP for East Choiseul.
For that explanation, I think with comfort him, I think just the fear of dividing. If you're a group here, will go on strike. And you need him numbers now. So what's the anyway? What members of one because of member trade union, but the go to him also. So okay, so that's one minute. But the understanding here is trade unions within the government system. Now we're talking about not you cannot be member of the Somnalis trade union or also.
Thank you. Honorable Attorney General.
Maybe if MP for East Choiseul can say.
Maybe the Somnalis trade union. That one, what companies do have members inside. What companies have got members of this trade. And what's if one of our company employees will go on strike, I would ask him what members of block or another company will strike with this one over this issue. And also, so the point here is that if this is not, you're talking about the trade unions confined or government services, no mind, or what people say, what the government freedom to join the Solomon Islands Workers Union, where what the private companies here, what the members live in. So there's potential of dividing, could be very chaos, and I suppose we need support of the public service for supporting a industrial issue. It could cause disaster to the country, Mr. Chairman.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for his choice for that question. In relation to whether private or for government purpose, well, starting point is every citizen got a right for joining a trade union of their choice, freedom which enshrined in the Constitution. Okay, so come down to each sectors, public and private sectors. The public sector, sort of everyone group come law, CPU, just because of the for want of the word, direction we're behind taken for everyone. It's one, class of group of people. So it's a class of people that the same background, which is government employees. Or as time you become law private, there are a number of councils, trade unions in there. I think you had SICTU, which is the Council of Trade Unions. Then all of a sudden you had the WUSI, Workers Union of Solomon Islands, all that. So those have, they represent certain, certain aspects of workers in the private sector. Now, for Leavers issue here, Russell Island, I believe there was one union that was actually furthering their issue at that time. And so the others joined another one because him no actually one him what like him for him waka forgot him. So the the ambits or the ambits of what each trade union is established for. Have no behind determining what action each trade union will be taking. For example, there might be a engineers association or trade union blue private. Okay, now blue government might join him, but when it comes to furthering their issue, they might say that once this all trade union him try for talk law government for issue whatsoever, it might not see the other aspects of what government employment is. So for example, in that sense, it would only be a technical area, which is just engineering. But when it comes to CPU, it's housing, it's other remuneration, it's travel allowances, it's everything that they collectively try to promulgate for members of Blokata. So those would be the differences that a private and public union would entail. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General.
Maybe a simple question. So the public servants can join private trade unions. Yeah, okay. The AG nodding head. That's where I'm really concerned, Mr. Chairman.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for his choice. Yes, that is correct. I'm also try for eliciting this engineer's case. You might be an engineer inside government. You would like to join engineers outside the private sector for furthering course of Logata and even upgrading skills, any kind of thing. You'd join that. But when engineers would like to go to industrial action, I think they would be in a much better place to be behind him CPU time him promulgating issues, because CPU would go for travel allowances, living housing, utilities, or same, and government as a whole. So yes, but constitutional right is you are free to choose. You're free to join any association or trade union you like. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I think that's why the concern by me, Mr. Abe. You know, when it comes to industrial actions, number become an issue now. Or we all need to support everyone who are members of this, and some members of public servants, and also join for supporting that cause once that one happened by but that's the policy choice, Mr. Chairman, by me, Lee Morrison, but there is some serious concern here, Mr. Chairman. That's why employers association kind of arrangement is something that is encouraged. And I think some other countries, Mr. Chairman, could outlaw trade unions because of industrial actions that are got potential for bringing down the nation. Mr. Chairman, that's the concern. So, but we'll leave it there, Mr. Chairman. We thank you for AG for explaining the policy rationale.
Thank you, Honourable MP, for his proposal. Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you to MP for his choice. It would be good for me also to just read him out what the Constitution and tell him just for clarity, for the avoidance of any doubt. So Section 13 of the Constitution and tell him that except with his own consent, no person shall be hindered in the enjoyment of his freedom of assembly and association. That is to say that here his right to assemble freely and associate with other persons, in particular to form or belong to political parties, or to form or belong to trade unions or other associations for the protection of his interests. So I'm not sure what the Constitution telling, but then I'm say too that, like we always say, although there are fundamental rights, each right is not absolute. There are restrictions also placed on those fundamental rights. So I hear him say, governments are making law for telling that all right in terms of interest law defense, public safety, public order, public morality, public health, and also too for protecting freedoms and rights for other persons, and also to imposing restrictions for public officers. So that's why you'll see also when it comes to private and public, certain restrictions will apply to public officers in terms of these fundamental rights, because Constitution and put them that we can do that by law.
Thank you, Honourable Attorney General. Honourable MP for Central Honiara.
Thank you, sir, and thank you, AG, for you reminding me about the section. In fact, it's the chairman and me before, me vala strike before. You ask a member that section, and I'm saving me vala. Otherwise, we would have been terminated from our employment in the public service. He was our president, law union before, chairman. But now I want you to confirm to me. So, in which category now CPM fall under? Trade union or a representative association? And which association in the public service are under which category? Would you have a list of them, Minister? Or, I mean, just for the benefit of the committee, no more for himself and no other one. Thank you, sir.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honiara for that question. at CPM trade union. That's why I'm going to industrial actions. The other associations inside the Government Lawyers Association, you got SINA, Somalis National Nurses Association, SIMA, Medical Association, SINTA. Those are other associations also, that one. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. With those comments, I'm now going to put a question. The question is that Clause 104 stand part of the bill. Those in favor, please say aye. Those against, say no. I think the ayes have it. Ayes have it. Clause 104, therefore, stands part of the bill. Clause 105. Any member wish to comment on this clause before I put the question? Clause 105. Thank you, Honorable MP for East Arare.
Thank you, Chair. 105.1, there seems to be subjective judgment given to the Permanent Secretary there in terms of his satisfaction or her satisfaction. Maybe there's a drafting thing there too, yeah? If he or she, maybe Putumava Samilo there before, if satisfied, maybe, I don't know. But the idea here is there's subjective discretion given. If satisfied that a significant number of employees are members of the association. This is in recognition of collective negotiations or negotiations through collective agreements. That significant number of employees, the definition of that, what would the minister say in terms of that particular phrasing? It's a percentage a little bit low there, or PS no more by him? And make him decision by him based on own subjective assessments, or is he going to be guided a little bit there? Or how not by him interpret him significant number of employees are members of the association. Significant number part here. Thank you, Chair.
Thank you, Honorable MP for East Arare. Honorable Minister.
Yes, thank you, Chairman. Thank you, MP for East Arare. But AGBM confirming come, I think the minimum number law as per the Trade Union Act, I think 6 members of an association. But by me alone, AGBM confirming them.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP, for for that question. And so to supplement, Minister, I think in terms of this one, I think the catchword here or the emphasis is on the Permanent Secretary being satisfied that a significant number. So a significant below that MGRM, it's more of a subjective test in this matter. Like, for example, within government, you might have a set of professional, skilled or skilled workers. So you have engineers, you have mechanics, you have teachers, you have nurses. Now, if you may put that you must guarantee significant number of some nurses for you be recognized as a association would be to discriminate against what are mechanical engineers, for example. There will be probably only 5 of them, let me say. Or if you say, if we were to have programmers, computer programmers, we probably only have maybe 3 fala or 4 fala. So if we are to put that same number, nurses or doctors or lawyers, to be recognized as lot of programmers or so would be to discriminate against them. So the PS has this objective, subjective test also for looking at yes. Although Trifala come for Trifal programmer come out like for negotiate for things, that's the whole of government in terms of programmers. So by putting a number would be to discriminate. So that's why the test here is PS number. I'm satisfied that him represent him a significant number of this skilled group of professionals. Thank you, Mr. Chairman.
Thank you, Honorable Honorable MP for Istarare.
Thank you, Chair. So yeah, we're talking here about for the purpose of negotiating collective agreements. I guess that's part law, some sort of action, maybe in terms of that Fala Association might bring him in, and then of course it's subjective because it's a significant number. We don't want to say what sort of number it is here. But then, what is your take on what Minister had pointed out in terms of the definition that we already agreed there? In terms of an employee association means the trade union is the meaning under the trade union. And if you read there, it's only 6 persons in a trade union to make it a trade union. I mean, that's my reading. I think that is what the minister was also saying. So a significant number is very subjective of that 6 year by Mosemo. 3 falo there no more, Mosemo, is that 4 fala or? I mean, there's already some sort of a kind of a number given for recognition of a definition of a trade union. And we seem to have already accepted that. So would it also be some guidance for us here when we have those sort of numbers already given in the trade union law, in the other laws on the Trade Union Act? So just wondering whether it's this fella significant number here is something that we could be more clear on, or to help the PS make the decision, or we'll just leave it wholly for his or her subjective judgment. Thank you.
The Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for starting for that question. Excuse me. In relation to trade unions, whatever requirements under that legislation, members will have to comply with, and that is set by law. For this group of employee associations, it's basically for the purpose of negotiating collective agreements. So maybe a scheme of service, let me say, for, let's say, if, let me say, for example, we put for computer programmers, if they want a scheme of service for them. But in the whole of government, there are only 3 of them. So if 3 of them come, that's a significant number of those employees who are computer programmers in government. So they qualify under this one to come and talk to, negotiate with PS in terms of their scheme of service for that particular type of job description. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. MP for Central Honiara.
Thank you, Chair. So, Chairman, I think it would be good to give me understanding how now the PS will exercise his judgment in determining what another significant number. So we need to walk backward. And then that's where my question lies. Look at the employee association, what would be the minimum and the maximum number that the PSM have to be, or the authority will have to be satisfied with to recognize them as the employee association? Because you say, I would not by trivial number, then they will be recognized as an employee association. What would be the maximum or the minimum number of membership for that recognized employee association? Perhaps that will make
work towards, helping PS for determining not just a significant number. Thank you, Chair.
Thank you, Honorable Attorney General. Honorable Minister.
Thank you, Chairman. Thank you, MP for Senator Honera. That's a very important point that you raised him. This one, by address him under regulation in terms of the process, criteria and the process. Thank you.
Thank you, Honorable Minister. With that comment, let me put a question. The question is at clause 105. Stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 105 therefore stands part of the bill. Clause 106. Any comment on that clause before I put the question? Clause 106. Thank you, Honourable MP, for his choice.
Thank you, Mr. Chairman. This is close here. The Bills and Legislation Committee of making a recommendation. That is recommendation number 62. And the Ministry actually made some assurance to the committee during the hearing. So maybe what not thinking law government for progress in that fella. That fella thinking that the Bills and Legislation Committee put in council recommendation number 62, Mr. Chairman. And then I think for the benefit of one, Mr. Redim, the committee recommends that clause 106 be clarified to require contract employees, especially those representing the government in remuneration negotiations, to renounce union membership through a specific clause in their contracts. And this will prevent conflicts of interest for those representing the government in remuneration negotiations. That's the specific recommendations to the government, Mr. Chair.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP, for his choice. So in terms of the recommendation there, every employer has got a right to join in any union or association, but when it comes to negotiating or got terms and conditions of contract or employment, but normally we address one of their contracts. Those people who are contracted there. So people who are under contract can still be member of the association or union. But again, when it comes to negotiating terms and conditions, those ones are incorporated inside of the contracts law. Thank you.
Thank you, Honourable Minister. Honourable Attorney General.
Thank you, Mr. Chairman. And I think just to add on to what Minister Hamtal, a contract in this sense is an individual right as opposed to a collective right. It goes, this one it's the negotiations of a term of contract between each individual party now. So only privity of contract will apply in this sense. That if it's between me and PS, only me and PS, no more by side talk about him because the union is not privy to any terms of condition in that contract. So basically what this means is of a contract of employment or the collective bargaining by side touching. But for you setting terms of contract, yes, but once it's set, when we negotiate each individual one, quite difficult because of privity of contract. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments on the clause? I put the question. Honourable MP for Central Honiara.
Chairman, that is always an issue in the past. Those contracts that are constructed where I'm only, privy to the one, that singular one time government. The moment you come up on them something that embarrass exorbitant, Hem na sabe trigam na o the man with the collective bargaining for come up on them issue law day. So you know this very well. Say and Attorney General to PM2. This is always the trigger of some of these reactions from our union union. So I think the only issue let us carry it out very cautiously, so that you may know trigger anything. Because now the law is very clear. The law was saying that that part, you follow bargaining part here, no look come to him. Blow the man the order rightly should be confined to it's a private thing, even though government is a public institution. But then you may treat him as private between government and all those that you mean by contracting. So a little bit small message for person, question him something, but this is one of the aspects that I'm always triggering now. Industrial actions in China government, and if it is not kept under control, by himself blown out into a very, very large-scale industrial issue within the public sector. Thank you, I say.
Thank you, Honourable MP for Central Honiara. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. Now, all it does here is preclude collective bargaining for a term of terms and conditions of a contract of employment. That on between individual who by enter into contract and for negotiating the terms of a contract. But the governing principles of a contract, that is where collective bargaining him coming. So by Ron come him say, okay, I want for everyone, you must give him housing, you must give him telephone, you must give him laptop. So, I mean, those are patterns, okay. When it comes to individual contracts, that's when you can, individual number him negotiate him, say, okay, I want, because of me higher than everyone, I want an S25. You cannot give me one for a house phone because with same with him everyone. Things are same. So that's why when it comes to negotiating terms and of a specific contract by individual number, and also too, because inside of that time government enter into, you'll have confidentiality clauses for say that whatever law here, you know disclose in Narawan too. So if the person him go him Talem Law Association blame for about the misal contract, that person is in breach of the confidentiality clause in the contract. So based on that, that's why we put it for collective. Not really, but if time what say no, oh, if I know like upon contractual terms, blow everyone, that's different. Okay. Thank you, Mr.
Thank you, Honourable Attorney General. Any further comments on that clause? Otherwise, let me put the question. The question is that clause 106, some part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 106, therefore stands part of the bill. Clause 107, clause 107. Any comments on that clause before I put the question? Thank you, Honourable MP for Central Honiara.
So, Chair, yeah. So these are claims that are going to be, and the difference here is just defined in the definition part of 103 here, yeah? Negotiations, that the claims will be made and the negotiations will involve, will mean negotiations about a claim, yeah? But there is also a caveat law there. It should not include negotiation that is conducted by way of proceedings under the Trade Unions Act. Law, I think, Minister, what is the difference of that claim and the ones that spell out law Trade Unions Act here? Can you enlighten the committee on that one? It's coming back to the definition law. 103, yeah, and then you apply it to the claims. Because the difference there is the claim, yeah, where it means a negotiation about a claim. So that is the one that is starting off from 107 onwards here. So what is the difference of a claim defined in here to the one law trade union act here? Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Senator Oniara for that question. The first obvious difference is that one is subject to another piece of legislation, which is the Trade Disputes Act, and this claim here is one that is subject to the Public Service, also Permanent Secretary, you to negotiate, whereas the other one, to our parties go before Trade Disputes Panel for that. So the other one is adjudicating one, and the other one is more of consensual yet. You may agree, whereas another one, you may adversarial position. You may go for someone determining. We've gone past negotiating, and we've now arguing it in a tribunal for a determination by a body established by law. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable MP for
So the difference in here is that, that is not a referral to the, so it's this claim over here, in the first place, we are avoiding referral to the trade dispute and then allow for some kind of a consensual negotiation between the parties. Is that the difference in it? So this legislation provides for that process first before activating the rights under the Trade Union Act?
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Senator Oniara for that question. Yes, that is correct. Just for illustrating simpler, this one, most sometimes beginning to negotiate with him, daddy, no more this time. No more so family gets the story, no more. Say straight, okay. But time you know, I'm not going to go to court now for who now by him, win or lose. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. No further questions. Let me put a question. The question is that clause 107 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 107 therefore stands part of the bill. Clause 108. Any member wish to comment on that clause before I put a question? Clause 108. Thank you, Honorable MP for East Joyce.
Thank you, Mr. Chairman. Again, bring the attention of Law Ministry and the government to the recommendations that the committee making recommendation number 63. The committee recommends that clause 108 be amended to include an explicit definition of good faith, and then over a little bit expound on that to ensure that negotiations are conducted in a legal, transparent, and financially sustainable manner. Mr. Chairman, because I think that in good faith there is a different application of it in law, in business, and general application of this term good faith. So what the committee, I think, what they're recommending, and capture now the legal, financial, sustainable manner, and then transparency, and also. So what not thinking government law that one, because I'm not defined, of course, under the Act, but these questions have been raised so many times as well. So what not thinking government law under law this, as far as this bill is concerned.
Thank you, Honorable MP for East Joseph. Honorable Minister.
Thank you, Chairman. Thank you, MP for East Joseph. Yes, so with regard to recommendation 63, in terms of the policy intention of disclosure, and me for providing, for promoting the collective bargaining negotiation, the claims to be made by all parties in good faith. Now, good faith may have different meanings in different situations, and thus may be best left with an open meaning rather than it be given a restrictive definition in the Act. Thank you.
Thank you, Honourable Minister. Further comments, Honourable MP for Central Honiara.
So, Chairman, so this part would be the main part of that first stage negotiations between the Permanent Secretary and our employee association. In the meaning of leaving aside this time now, the other part of the Trade Union Act here. So it's a very, I think it's a very good avenue that has been created in this legislation to reach some kind of an understanding without having to go deeper into the trade dispute, yeah, I mentioned. So, Chair, and the principle that has to be applied here is the balancing principle, yeah, of the interests of both parties. So one party, somehow this law only provides for defining the interest of one party, which is the government. And the interest law there is in subclause 3. Affordability, productivity, upholding the public service value. What about the other party's interest here, which is the employee's interest? Do you think, AG, or maybe Minister, why not you mean state him lawyer, these interests too, the employees need to state him so that, in the first place, this whole process of exercising this negotiation in good faith here can, as we always say ordinarily lawyer, him flow now, him flow good to that outcome. As it is, it seems that interest flow government no nudge the kind of outcome in this balancing out negotiation here. What do you think, Lohem? Do you think that interest flow employees should also be defined in here so that they can confine their negotiation in that way too? Or both parties' interests should confine into affordability, productivity, and upholding the public service values. Something was in there. Yeah, say. What's your take on that, Minister? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for Honara and Chairman of the PAC. Yeah, so I think the intention here is for allow what for come in freely within what now or come for negotiating. The interest of the government is as a guideline for what now the negotiation by yeah, but so when we look at this sort of term in good faith here, I'm really sort of concerned about honesty and sincerity of intentions whereby I'm put on the table for negotiating no mind. So here I think it gives more and give allowance for all the prim coming what agreements is blocked and then even negotiate them together in good faith. So this what the interest of the government including this bill, just providing me with a guideline what now government by look in terms of our negotiation. I mean affordability is one, as in there, productivity and upholding the public service values. Thank you.
Thank you, Honourable Minister. Honourable Attorney General.
Thank you, Mr. Chairman. And in addition to what Minister Talem, coming back to the first part of the question, which is good faith, defining good faith. In terms of drafting and say development of legislation, we've always tried to shy away from defining good faith for a number of reasons. One is time by me defining, there's the risk of narrowing or distorting its intended meaning, especially time by me go to courts time by defining good na what you mean defining good faith, you mean restricting courts from declaring it as bad faith kind of thing. So we usually leave it to courts to do that defining. Now, also too, context determines content. Why we tell them that is, for example, in employment law, good faith implies honesty, fair dealing. Yeah. If you may say public administration or admin law, it's acting without bias, corruption or ulterior purpose or ultra-virus or sin. In contract law, it's about performance and enforcement. So it has a different connotation in its different aspect. So that's the risk of when we define it, we narrow its purpose and we risk distorting its meaning. Okay, now coming to question of law MP4 Central Honiara, why no government na you may put an interest blame? It's because government is supposed to be acting in the best interest of the people. So time you may look at Muslim, what you may protect the interest of the people, basically affordability, taxpayers' money, productivity, now we like water for saving more people, and upholding the public service value. So those are public interest matters, and government, why we have to put government's you may say interest not legislation is because the government is for the people, and what you may say, what everyone must look in that when government does its job, this is what it must portray, or what it must perform. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Any further comments? Honorable MP for Central Honiara.
I think it's a very fair observation or an opinion, and I think it's a very strong opinion that has been put forward by the AG on this, especially flashing out the interest of the government law there. But in a government machinery, it involves government defining there and also the workforce there. I mean, this workforce or the labor force have now changed their, supposed to be, their loyalty to be or the workman was state na yeah. So in a way that we allow for negotiations on matters like this, meeting us, and it is important to put those employees also part of that government machinery too. They should be part of that government machinery. They should all be defined together as part of government now. Because without people, institution usually here. It is the people that give breath to it, life, thinking, and all of this, ideas and all that. So, meeting was up close 3 years, that the interest that both parties must observe, and not this one, instead of just putting it just on one side. Because even over the man that Baba negotiated on behalf of government, yeah. Sampai lo ada ya, ada wakaman tu ya, apa ya, wakaman PAC, wakaman no ya, ada man we ada by kamsi dan lo di ada party, ada wakaman tu ya, apa sih? So we should have a more inclusive description of the way that the interest then should be applied, lo there, yeah? To say that both parties, government and the employees' interest here, must observe not this one. I mean, almost multi-thing it's not a big one, said. But it's something, to, in a way, really, push him now, this whole idea of a more inclusive, interest inside the government machinery. Thank you, sir.
Thank you,
if you agree, we make him change that the interest of both parties must be confined to this, something was him. Yeah. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. When it comes to articulating what the rights of the employees have labor law come in now, so we must comply with the labor laws in terms of that. So that's why we don't state it here, but the labor laws will outline whatever rights of the wakaman got. And also, you got a Workmen's Compensation Act, you got a Workmen's Liability. So those are covered under that specific legislation. So in this case, it's just about the public service. So whoever comes in to work in the public service, these are what we require and what is put in front of everyone that is aspiring to be in the public service. But yeah, in terms of why you putu minsa lo here at interest lota wakaman hem alo lebal lo blue mina by minsa. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable MP for East Arare.
Thank you, Chair. I think some good discussions here. I'm listening to both. Yeah, I'm starting to feel also no need for listing no more. Government interest in man. I'm implied now, lo. Everything in me here, also, I think it helps the government too for have that flexibility in terms of these negotiations. We have that overarching good faith already there. I think the fact that it's really, our interpretation is quite open. I think it's good. But I think we might be shooting ourselves in the foot. Minister, I mean, we, but the government, Minister, I'm not sure, might want to look at this issue with all this meaning and the intention given. I'm just thinking about the value of having that there. I think there's also value in not having it, but having it understood and implied, and gives that flexibility as well to the government side when both parties come together. Just an idea. Thank you, Chair.
Thank you, Honorable MP for East Arare. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Arare, for that question. As you can close sub-clause 3, I'm just saying interests of government include, so that means it doesn't preclude a number of other things too. It just says this is probably minimum where you may start him off with him, then we come in negotiation. So I take your point that sometimes some things are better left answered. I think the policy choice is to have it in there as a minimum. Let me say minimum term. That's when you come into negotiation, at least persons sitting there at the negotiating table at least have a benchmark that they can start negotiating to, rather as opposed to just come everyone come clear to what now on the table. But whereas this one, there's a starting point that this is on the table when it comes to negotiating claims. Yeah. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. With those comments, let me put the question. The question is that clause 108 stand part of the bill. All those in favor, please say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 108 therefore stands part of the bill. Next clause for constraints, the clause 109. Does any member wish to comment on this clause before I put the question? Clause 109. Thank you. If there is none, I'm going to put the question, and the question is that clause 109 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. Clause 109 stand part of the bill. Clause 110, 110. Does any member wish to comment on this clause before I put the question? Clause 110. Honorable MP for East Choiso.
Thank you, Mr. Chairman. So just for clear and also when it says that a claim may be determined, well, clause 110 and may refer to the determination of the claim. So the claim may be determined and to further A and B, if it is referred as a trade dispute to the trade dispute panel. So just this word may be determined. This one I'm actually minimum subject to the TDP processes to deal with the issues of contention. I'm going to TDP now because he knows I solve him now. So it's just, so we understand the word determined in that way, Mr. Chairman.
The Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for his choice of that question. And basically, here, I think the intention of this clause is basically for parties to see that there are two ways we can have an outcome. One is if we control the outcome. One is if that outcome is controlled by another party. So we choose which one you mean. Like this clause is. It's there to what's the word? A positive reinforcement. So it's there for me try for engage in a claim whereby you say determining outcome as opposed to refer them. But there's that option to refer it in any event as the last resort in a claim. But once you rightly tell them to that once it goes there, it's beyond our control. It's an award, and once an award comes, then you still have the appeal process to come. If you know agree them, you should appeal go to High Court. Then time High Court, appeal what High Court tell them, appeal go to Court of Appeal. So it still goes. Whereas the other one, we can be assured of a finality. Time we shall have agree. Thank you, Mr.
Honourable Attorney General. The Honourable MP for Central Honiara.
So, sir, yeah. So the critical point now is where determination of a claim has not been made and where it may have been made. So AGU in 109 subclause 3, at any time normally, yeah, that's the catchphrase. At any time before the claim is determined. So who not determining not just for claim here. Determined out of that negotiation or from where? Who signifies that a claim has been determined, yeah? Where now that which point number by I'm reaching. Then anyone can refer it. That's where 110B, yeah? That's where 110B by trigger naya, like that. Or will you also have a provision where there is an unacceptable determination? Do you foresee that part, Minister? Yeah? Even before determination is being reached? Yeah? Or, well, after the determination is being reached, but then the parties have not accepted it. Say, for instance, the employee association have not reached it. Will they ever be given a chance for them to make a referral to the trade dispute, or is that something I'm final now? I'm not saying. Thank you, sir.
Thank you, Honourable MP for Central Honiara. That provision 1093, I think the reference to 110B is in perhaps pursuant to the outcome expected if arising out of 1093.
Yes, exactly, Chairman. I understand that part. That's what, I have just described. That 109 sub 3 can allow for referral, yeah? AG? Law 110B. Yeah? That allows the referral to 110B.
For settlement, not referral. Referral is 1093. That's a referral. Determination is 110B on the referral from the previous clause.
Yeah. Yeah, I have no one meaning. So but there's also one part, let me just try for suggesting. No more. Would that be also another provision that, for instance, a determination has been made through that collective negotiation? Yeah. Is there a provision for an unacceptable? Because the law do provide for something described as that to you, unacceptable settlement. For instance, in a local court law, yeah, there is such principle was there was a determination made, but unacceptable. So I would refer it to the next
level for adjudication or something. Will there be a chance for this this legislation? I'm no more question. Let me ask him. Come, Chair. Thank you. You know you want some give go money enough.
Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honera for that question. I think just to elaborate more on as Chairman and Talem, 1093 basically, I'm saying if you go to go, me still, me no happy with how I'm progress. There's that avenue that me say what now want to me say Torongo Festna go TDP for him determining before you may come to a determination by way of collective agreement of 110 or any so that will become a referral as Chairman Talem under 110B of that claim to be determined by TDP. Yes, thank you, Mr. Chair.
Thank you, Honorable.
So the next part, I mean, that another possibility, me suggest him come, which is not here. What if they reach a determination, and their determination near be order reaching here? Somehow, maybe 1 hour or 2 hours after that, no more, and the larger or the other association had decided that, you mean to accept him this one. Is there a provision for that? Thank you. I'm no more one, me like to ask.
Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP, for Central Honera for that question. So I assume your question would be that the award given by TDP is not accepted? No. The claim outcome?
I'm referring to the claim here, Jila negotiation law claim here. Somehow, if they reach some kind of a determination, but then the other party, maybe possibly, it's always either the government side or the, will they have a right to refer that as unacceptable determination, or both sides, government side and the employee side?
Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honera for that question. So, one thing basically talk about determination of claim by way of one collective agreement, two whether it referred to TDP make him award. So, in the circumstance where you enunciate him is that as soon as everyone sit down for agree, but time collective agreement Muhammad disagree. So that is not a collective agreement as what 110 him envisaging. So that will now become a referral, but not a collective agreement. It's up to any party to sit down, you may go, time. If you may run sit down, you may agree, you may second, yes, this is it, you may sign. Then that is a claim determined under 110A. But if it's not done in that way, someone dispute him, and will refer him, and not like him, or him refer him, then it will be a claim determined by way of 110B. Thank you, Mr. Chairman.
Thank you. Honorable MP for East Are.
Thank you, Chair. I think the idea of determination and what it means, I'm grappling with here. In terms of 109, which we already have moved past, talks about referral of the claim to the TDP. And then 110 is about determination of claim. Seems to be some finality in terms of that. The wording normal 10B, it's still talking about referred yet, and whether referred is actually a finality, in terms of that, or if it is for settlement, it's A talks about a collective agreement, or B, if it is settled by the trade dispute, as a trade dispute by the TDP. That to me seems to mean more of the meaning of determination of that claim is settled, rather than you may just refer to him, that means it's a determined, the fact that based purely on a referral. So I think that when I'm struggling, what's the policy choice here? We feel that it's already being determined once the referral is done, or do we want to say determination of a claim is when it is settled, which might mean some drafting a lot there, a lot 10B. I take that because in 109.3 we're already talking about referring. So I'm thinking logically the sequence would be by the determination would be by a settlement done by the TDP. So it would read, if it is, for example, it may read as him, if it is settled as a trade dispute by or something, the trade dispute panel, by an order or something, and then we've met that determination now that it's been determined, the claim has been determined. Thank you, Chair.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP, for Istarare, that question. So, Division 2, this part of Act, him actually talk about in collective bargaining. So, in collective bargaining, there's two ways it is determined. One is time you run agree and determined. Time him being referral, him being referred, it's determined to him in the sense that it's no longer going to be a collective bargaining because him go for adjudicating, it's going for someone to adjudicate the claim. So collective bargaining will no longer take place because we've now left that space for another space, which is courts and TDP. So that's why a determination it's a determination in the sense of collective bargaining, that we no longer subscribing to collective bargaining of this claim. So the referral is determining that you may stop negotiation, you may stop bargaining, you may refer him go for someone him determining claim against him, who now win, who now lose. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General.
Okay, so that's all right. So
Control Honiara, please.
yeah, so in this claim, it's either settlement will be achieved through this collective bargaining or collective negotiation. So both parties will negotiate, and hopefully they will come up with a collective agreement. So the collective agreement will possibly spell out what's the terms of that collective agreement, whether it is final or they might end up with an unacceptable, and therefore it goes to the next stage, which is referral to the trade dispute panel, which will be B, Yaman, MOSME, by an order or award under the. Do you think that would buy him right for stay there, or we should get that out? Yeah? B, if it is referred as a trade dispute to the trade dispute panel by an order or award here. What you're thinking on that, AG? Meeting him by him will make him something a little bit party and borong that. Would be, do you think, for an award or an order under the Trade Disputes Act would be appropriate? Thank you, Shay.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honiara for that question. The use of the word by in there is directly relating to the determination of a claim. What is it determined by an order of the TDP? So first one, what is it determined by? By a collective agreement. Second one, what is it determined by? By an order of a TDP, as being referred to it as a trade disputes panel. So trade disputes are dispute. So I would think that having the buy-in there is critical, to have it in there and refer to the actual, you may say, doing what we've been said here. Then thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable MP for East Are.
Yeah, thanks. Yeah, it was in my reading of the whole thing. That was why I was trying to suggest that, including the word by, as Central Honera said there, like the dispute by an order is referred by an order. Referred and then by an order. And I'm not sure if it's referred for an order. I think that might make a little bit sense more. I mean, the idea is we seem to be drafting, and I'm not much clear on me, Chair, in terms of this particular issue, that if we're going to keep referred there, it's referred, then for an order that will be forthcoming, yeah, by the trade disputes. I mean, that one for me, then this fella, and then with the explanation by the AG about somehow determination is imi wash hand nalo. You know, we washed our hands on this now, you know, pilot ponchos, imi wash hand, you gotta take him go to next level one, I mean, enough now. But I think if we put that in there, it might, in sense of my reading, and perhaps that's what Central Honera too and try for reason, that might make more sense. This is just our thinking. Thank you, Chair.
Thank you, Honorable Attorney General. Just part of it, so that look at the Trade Dispute Act, when it makes a determination, either by an order or through an award. I think look at what the Trade Dispute, otherwise the quotation there, only the Trade Dispute Act, under the Trade Dispute, Trade Dispute Panel, under the Trade Dispute Act, can award, okay, if a settlement, and that is if both parties don't agree to any consensus. Of course, one party, in the end, once you refer to the Trade Dispute Panel, it's final. It will make the award, either by an order. What's the definition by order? Is it by virtue of a wording in the Trade Dispute Act, or an award? What's the difference between the two? I think, Honorable Attorney General, if you can take us through the Trade Dispute Act in the provision applied to the settlement of negotiations. Thank you.
Thank you, Chairman. If I can just also make a small contribution to this clause, clause 110. A straight reading of this one said, aim to achieve two things. One, for settling that claim, parties come to a negotiating table, and if they agree or come to a consensus, and what settling, that's settlement and finish now. Clause B, subsection B, talk about that the matter has already been referred and has already been settled. So a matter can be settled by agreement, or if it has already been referred or settled by TDP. That's the simple reading law this one. That's my comment. Thank you.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Istarare for that question. So, in addition to what Minister Law, Province of Government and Talem, I think best for Imiridi Mosem. So, 10B, 110B by Imiridi Mosem. If it is referred as a trade dispute to the Trade Disputes Panel by virtue of 1093 by way of an order or award under trade dispute, this claim may be determined. Also, if you read it in that context or in that sequence, that's what it means. So it's basically just a referral of what 1093 hem talen. If you refer to that, how hem determined by an award given by that body that is being referred to. Thank you, Mr. Chair.
Thank you, Honorable MP for Central Honiara.
Thank you, Chair. No, I raised that point earlier on, but then now I have actually connected the where it comes from.
Law 110, determination of claim here. So you can read it like this. A claim may be determined, and then you put a comma, there's a colon there. If it is referred to the trade dispute panel by an order from the, or award under the Trade Dispute Act. I'm not how me read him go. So I think it's all right, no more. Thank you, sir. Yeah.
Thank you, Honourable MP for Central Honiara. And with your concurrence, I will now put the question. The question is that clause 110 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 110 therefore stands part of the bill. Clause 111. Does any member wish to comment on this clause before I put the question? Clause 111. Thank you. If there is none, I'm going to put the question. The question is that clause 111, 111 will stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 111 therefore stand part of the bill. Clause 112. Any member wish to comment on that clause? Clause 112. Thank you. If there is none, I'm going to put the question. And the question is that clause 112 stand part of the bill. Those in favour, please say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 112 therefore stand part of the bill. Clause 113. Any member wish to comment on this clause before I put the question? Clause 113. Sorry, Honourable MP for East Choiseul.
Thank you, Mr. Chairman. Again, we refer the Ministry of the Government to the report of the bill's legislation and committee. Just get the Thinking Law, Government Law. The recommendations that is made, recommendation number 64. The committee recommends that clause 113 be amended to include an aspirational objective to avoid strikes, encouraging both the government and employees to resolve disputes through dialogue and cooperation while preserving the legal right to strike where lawful conditions are met. What now Thinking Law, Government, and how I'm accommodating that fellow, that thinking, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for East Choiseul. With regards to the recommendation 64, the strikes are covered under the Trade Dispute Act. Also, employment relations are provided for in this bill in Part 11. Managing this relationship with unions and associations is important. So that's, but by way of regulation, as per Clause 134, would also specify a process for managing unions and associations. Thank you.
Thank you, Honourable Minister. Any further comments on that clause? Thank you, Honourable MP for Central Honiara.
Thank you, sir. Sir, as you know, activism involved in a lot of forces, not only strike. You could have protest, possibly absenteeism from work, not full day, maybe half day no more. All other forms of, we can say, behavioral kind of actions, yeah, emotion. So in here, by naming it OSEM strikes no more, yeah? What does that mean, Minister? Do we still open mouth, not protest it? I mean, sometimes protests are made less than 1 hour no more, less than 2 hours or same no more, or activities like that. Will such actions can still be entertained in this law, or will that amount to also some unacceptable behavior from all the unions believe? Thank you, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for Honera, and also Chairman of the EPAC. So, as I mentioned earlier, the regulation by Commander Clause 124 now by specifying what process for him managing with relations. So, to making sure that even entertaining several behaviors whereby him also creating risk to the public and also by bringing more challenging issues for him. Thank you.
Thank you, Honourable Minister. There are no further comments on that clause. Let me put a question. The question is that clause 113 stand part of the bill. Those in favour, please say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 13, therefore, stand part of the bill. Next clause is clause 114. Any comments on that clause? If I put a question, clause 114. Thank you. I see none, and therefore I'll put a question. The question is that clause 114 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 114 therefore stands part of the bill. Clause 115. Honourable members, there is an amendment proposed to this clause as appeared in on provision order paper number 63, and I'm asking the Minister to move the amendment. Honourable Minister, sir.
Thank you, Mr. Chairman, sir. I move that clause 115 is amended at the code maximum penalty and code by substituting code 5,000 and code with 50,000 and code 6 months and code to 5 years and code. The purpose of this amendment is for also addressing the recommendation 65, Lobbying Legislative Committee, and also for aligning what penalties here with other relevant legislations. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Honourable MP for Central Honiara.
Yeah, so that alignment here now, can you just give an example of the equivalent kind of offences that are already enforced? That they may apply in the same kind of a penalty that has been recommended by you.
Thank you, Honourable Minister.
Say that because you say offences in the public service.
Thank you, Chairman. Let me allow my AG for clarifying on that one. Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. In terms of penalties, these are the ranges that I'm looking across the board. If it's 50,000, and it's between either 3 to 5 years or so. Between 30,000 to 50,000, between 3 to 5 years. So I'm not a ranges here where I'm looking across the board. Lot of offences being. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Honourable MP for Central Honiara.
Yeah, I mean, I understand that, but in terms of the kind of offences here, one represents by words or conduct, yeah, or some new tokonuma or certain conduct play, or you representation is you falsify representation or same, yeah, so any offense and the penalty, yeah, so that is the offense, the penalty. This is a part offense where me matching that kind of a penalty, and I mean law. Any other laws blame me, because one of them is a law leadership code here. I have him law for good here. Para law for good. For instance, you know, you may Savala no give him go information, but penalty $50 no more. Yeah? So is that fair? Yeah? So me ask for example no more, you know, say that yeah. Committee, so for ask for example no more, I know, you know, other legislation or other legislation where those penalties are way, way below lower leadership court one. Some file believe full empty, I would say. I mean, I didn't say that. But some file lomi falaya, bar I think go here now. So you will travel go to declare go to make him file believe same size everyone no more. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara for that question. Now, you will see, for example, Police Act, 30,000, 3 years. Law Electoral Act, 20,000, 2 years. Law Anti-Corruption Act, the range, it's consistent with the ranges where you put in, so 50,000, 5 years, 20,000, 2 years, 30,000, 3 years. Thank you, Mr. Chair.
Thank you, Honorable Attorney General.
Jose, if you say that, thank you, AG, for you giving some example. In here, 20,000, but then 5 years. I'm still talking about the amendment. Yeah. Do you think, Minister, you should align him on them or whatever AG just tell him come? Him 30 but 3 years. Not the same as him. Where time you go along somewhere, so same 15 horsepower and 15 minutes too. Or same here. Not that. I think with here 30,000, it's 3 years. Yeah. So in here it's 20,000. Why don't we go up? 50,000 is 5 years. So in terms of this amendment that you are suggesting, Minister, I think to commensurate with the figures where we come here, here it's 20,000 and it's 5 years. In the police one, it's 50,000 is 5 years. So what do you think on that amended penalty? 20,000 should be 2 years, yeah? So that 30,000 is 3 years. Something was same, yeah? I'm was same. And again, going back to the common jokes that everyone got in here, like somebody asking question, you know, how far does it take from here to there? You know? Well, if it's 15 horsepower, it's 15 minutes. If it's 40 horsepower, it's 40 minutes, like that. Yeah. That's not quite, you know, what I was trying to drive at, you know, to try to get some equity or fairness law here. But I think AG has just given some very practical example. 50,000 penalty units is how much? 5 years. 30,000 penalty units is 3 years. So 20,000 penalty units surely and fairly should be 2 years. Cannot be 5 years. That's my argument, sir. And if the minister could accept that, then only him can put the amendment. Otherwise, by penalizing board, public official, I think they will have a right of appeal to the Court of Appeal here. I'm not sure. I mean, if anything like that can happen. Thank you, sir.
Thank you, Honorable.
The Minister, if he can rethink that.
Honorable Minister.
Thank you, Chairman. Thank you, MP for Central Honiara. Yeah, this amendment is done after consultation with him, with other agencies like the Law Reform Commission, and that's the recommendation that he have come in. So this amendment, and others by coming behind to him. That's what I tell them. You follow that every amount to change the law bill. So this try for harmonizing now with what other legislations. And as I said, the immigration recommendation, law reform commission. Thank you.
Thank you, Honorable Attorney General.
Oh,
Thank you, Mr. Chairman. Thank you, MP for Senator Honiara for that question. I think the amendment, the current penalty law here is 5,000 penalty units and imprisonment of 6 months, but the amendment is to 50,000 to 5 years. 50,000 penalty units and 5 years imprisonment. And not amendment where it's brought to this time.
Thank you, Honorable Attorney General, and that's a maximum, right? So there's still scope within the range, depending on what the penalty applied. If it's less than 5 years, then of course it probably would be also less than $50,000. So that range, I think, that's why it's a maximum. That's
Chairman.
the wording there.
Yeah, my ear misled me. I wasn't reading the amendment. I was hearing the minister now, meeting saying 50, but 20, it was 50. So I think I'm straight now, leave him there now. Thank you.
Thank you. And with your concurrence, let me put the question. The question is at clause 115 as amended. It's amended at maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 115 as amended, therefore stand part of the bill. All those in favor. So let me put the question. I think the question is that clause 15, the clause 15 therefore stands amended accordingly. But before I put the question on in respect of that clause, does any member wish to comment on that clause as amended? Is Arare?
Yeah, thank you, Chair. Just a quick question in terms of how often this happens, or any case you will be looking to discount that man around an MCM, man law public service, and you will actually catch him, just for our interest for Parliament. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for Isarari. Impersonation, I mean, a little bit quite rare, but legislative government became even allowed to man for come over a mask and tell them who know. Thank you.
Thank you, Honourable Minister. Any further comments on that amendment? If not, I'll go to put the question. And the question is that clause 115 as amended stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 115 as amended, therefore, stand part of the bill. Clause 116, honourable members, there is an amendment proposed to this clause as appeared in the provisional business paper number 63. Let me ask the Minister to move the amendment. Minister.
Thank you, Chairman. So I move that clause 116 is amended at the maximum penalty by substituting code 5,000 and code with 20,000 and code, and code 6 months and code to 2 years, code and code. Thank you.
Thank you, Honourable Minister. Again, it's
yeah, thank you, Chairman. Again, this is an amendment for harmonizing this legislation with other legislation. I think me just looking where now, and people also looking 20,000 talk about him today. Him disappeared this time, yeah, so thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you. Honourable MP for Central Honiara.
One part of the law that we normally who got caught up with this kind of an offense now, or statistics act. It's a very powerful act, but then I don't know, inadequately enforced, or got him same powers as Commissioner of Inland Revenue too, statistician. If you can't be allowed to blue or any place for ask for information you feel for, got him powers same as a magistrate, no more government says. Just by way of interest no more, do they have offense? Because you know this kind of offense will be common in the statistics space. Do they have the same kind of penalty as well? Just by way of interest, now both of you are maybe Minister and AG. Just for comparing no more, you know, whether or not they have the same kind of, yeah. Thank you, sir.
Thank you. Honorable Attorney General. Thank you, Honorable Minister.
Chairman, can Mr. Asker MP for Senator Honor for repeating what I mentioned earlier, please?
Most definitely, yeah. Me say that this kind of offense would be almost the same or relevant along statistics under the Statistics Act. Yeah? So we just like to know whether or not they have maximum penalties for failure to provide information or statistics or data to the government station would attract the same kind of a penalty too. You were talking about harmonization of all offenses, penalties and all that. Have that been, is that the case? And if so, then I think you should accept him this one no more. But I know penalty law, that one, yeah, very low, yeah, low statistics here. That must be. Thank you, sir.
Thank you, Chairman. I think me just get him here with me. The other legislation we have got them same penalty. So under the Police Act 2013, Section 117, penalty 5,000 penalty units or 6-month imprisonment for the same for failure to provide information. I think the same with the Electoral Act 2018, Section 117, but the penalty is 20,000 penalty units and 2 years imprisonment, or both. So that's what me. Thank you.
Thank you, Honourable Minister. Thank you, Honourable MP for East Choiseul.
Thank you, Mr. Chairman, just for AG clearing come. So once my go to prison, I'm still no. He still has to provide this information. And by go to prison, if I fail to, then pay for 5 years. That doesn't clear him from, I must still provide him this information that is required.
Thank you, Honourable Attorney General.
Thank you, Mr. President. Thank you, MP, for East Choiseul for that question. The obligation to provide information on stage, no matter you go to prison, but obligation is stopped. Each time you don't provide that information, it's an offense. So every day you don't provide it, it becomes an offense. Also. Thank you, Mr.
Thank you, Honourable Attorney General. Any further comments on that amended clause? Otherwise, let me put a question. The question is that Clause 116 is amended at the maximum penalty for substituting 5,000 with 20,000 and 6 months to 2 years. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 116 therefore stands amended accordingly. Before I put the question on that amended clause, any member wish to comment on that clause as amended? Thank you. Honourable MP for Central Honiara.
So, Chair, where an employee in terms of the description of the offences in here, fail to provide the information in the form that the Commission may require him to give. And if somehow that information is being furnished, will that not grant him some kind of a remission in that way, or this is who's going to determine that? Yeah, is this something that by the court of law, not by him determining, or in the way that the commissioner by him presenting in the court of law? Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara, for that question. In terms of offences, only courts know what's a fine and guilt, because you have to go through trials, and constitution Italian. So once you don't provide that information to the commission, and the commission sees that you have unlawfully withheld information or documents, and report them, you go to police make a investigation blame, formal charges laid, and yes, after trial, whether courts convict him you or not, that's when these penalties will be applied. So the courts fine him you, or him say you go to prison, him discretion law court. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments? Honourable Chair, PAC.
Thank you, Chair. So, with that explanation, AG, that's excellent. So the right of defence law, an employee would be as the Constitution, according to the Constitution, the right of defence law has to be as the Constitution and provide for. Yeah? Thank you, Chair.
Thank you. Thank you, Honourable Chair of PAC. Honourable Attorney General, please confirm his observation.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara, for that question. Yes, in our Constitution, you are innocent until proven guilty. Thank you. Mr.
Thank you, Honourable Attorney General. And with that, let me put a question. The question is that clause 116 as amended, stand part of the bill. Those in favour, please say aye. Those against, say no. I think the ayes have it. Ayes have it. Clause 116 as amended, therefore, stand part of the bill. Clause 117. Honourable members, there is an amendment proposed to this clause as appeared again on the provisional business paper, and I will ask the Minister to move the amendment.
Thank you, Mr. Chairman. Sir, I move that clause 117 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. This one, again, this for amendment for harmonization of bill within the Electoral Act 2018, Section 113, and the Ombudsman's Act 2017, Section 31. Thank you.
Thank you, Honourable Minister. Again, please, any member wish to comment on this proposed amendment? Before I put the question. Thank you, Honourable MP for Central Honiara and Chair
Yeah.
PAC.
Thank you, Chair. Me have the Electoral Act and also the one Ombudsman Act. Yeah. How about the Statistics Act? Statistics Act.
Honourable Minister.
Thank you, me. But I ask him, AG, for clarifying that one. Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP, for Central Honiara for that question. Unfortunately, we will not like the amount of penalties in the Statistics Act. In the Statistics Act, the penalty is lower than 1 year, range 1 year and fine of $7,000. The other one is 2 years and fine of $14,000. And that's the highest law in general, Statistics Act. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments on that proposed amendment? Thank you. If there is none, let me put the question. The question is that clause 17 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. All those in favor, please say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 117 therefore stands amended accordingly. But before I put a question on that clause, any member wish to comment on that clause as amended? Thank you, Honourable MP for Istarare.
Thank you, Chair. Just to ask more of the same question to the Minister and probably the AG in terms of giving false information and false and misleading information. Has there been any individuals caught in this, perhaps under the other acts already? Was this seems to be something that perhaps is more common. Lakas Nomasen. Thank you.
Thank you, Honourable Attorney General. Sorry. Honourable Minister first.
Yeah, thank you, Chairman. You may not get many case where in relation to this giving of false or misleading information in the public service. Thank you.
Thank you. Honourable Minister, any other comments or observations on that clause as amended? Honourable MP for East Choiseul.
Thank you, Mr. Chairman, just for AGO, Mr. clearing cover. The penalty is heavy, 50,000 and 5 years. Now, the under 17.2, misleading information, there must be deliberate misleading information. In the case of omission, Mr. Chairman, is there such a thing as honest omission? If there's such a case, a situation, then I guess it's a matter for pleading in court now. Also, if I'm not meaningful or meeting this information, but I'm putting penalty 50,000 euro and 5 years imprisonment. So is there such a thing as, so the court must I guess be satisfied that it is a deliberate effort by this person to mislead. Thank you, Mr. Chairman.
Thank you, Honourable for East Choiseul. Honourable Attorney General would like to comment on that observation.
Thank you, Mr. Chairman. We just didn't get the last part, question.
Honourable Member.
Thank you, Mr. Chairman. Clause 117.2, the definition below misleading information means information that is misleading in material particular or because there is an omission of a material particular. Maybe the last words there probably qualified that omission, and the question was a case where the person was honestly omitting some information there and not deliberately meaning. I guess that will be a case for an issue for pleading in the court now. Mr. Chairman. So it's such a thing as honest omission.
Thank you, Honorable Attorney General.
And thank you, Mr. Chairman. Thank you, MP, for his choice of that question. In terms of an example, whether that Mbaminose answer you at this moment, I could try and ask the DPP. It's more of a DPP area law, criminal law. But I would think that here is because of context. Law always responds to context, so this must have happened in the past that Amy put him inside Lata laws. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Any further comments? Otherwise, I'm going to put the question. The question is that clause 117 as amended stand part of the bill. Those in favor, please say aye. Those against say no. I think the ayes have it. Clause 117 as amended, therefore, stands part of the bill. Clause 118, again, the Minister, there is an amendment proposed to this clause, and I will ask the Minister to move the amendment. Honourable Minister.
Thank you, Mr. Chairman, sir. I move that clause 118 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. Again, this one I mean also harmonize with him now the Ombudsman Act of 2017, Section 33. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, any member wish to comment on that on this amendment? Thank you. If there is none, let me put a question. The question is that clause 118 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. All those in favor, please say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 118 therefore stands amended accordingly. But before I put the question on this clause, any member wish to comment on the clause as amended? I see none, and therefore I will put the question. And the question is that clause 118 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 118 as amended therefore stands part of the bill. Clause 119, honourable members, again there is a proposed amendment to this clause. I will ask the Minister to move the amendment.
Thank you, Mr. Chairman. I move that clause 119 is amended. A, at subclause 1, at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. Again, Chairman, this one I may harmonize with the Section 190 Law Police Act of 2013 and the Section 138 of the Penal Code. Thank you.
Thank you, Honourable Minister. Any comments on the proposed amendments before I put the question? Thank you. If there is none, let me put the question. And the question is that clause 119 is amended. A, at subclause 1, at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. And B, at subclause 2, at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 119 therefore stands amended accordingly. And before I put the question in respect of clause 119, does any member wish to comment on that clause as amended? Thank you, Honourable MP, for Central Honoran Chair of PAC.
Yeah, Chair. In terms of the offense number, subclause 1C, government property here, does that include movable assets? Movable assets, Minister? Movable assets, including vehicles or something, furniture, something. Staka people, government, to doing this kind of government assets here, go all about normal properties. Thank you, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Chairman of the PAC. You have me inclusive for your assets. Thank you.
Thank you, Honourable Chair of PAC.
This is almost, related and relevant to even all the kind of offences that would have been applied in the case of Public Finance Management Act, where the Minister of Finance or MCRT can actually impose surcharge, surcharge along those that have abused him now or the government assets. Is it okay to you for aligning all the offences here and the penalties together, with those legislations so that, we can really pitch, the kind of high risk that be prevalent inside the whole of the government machinery system. Meeting all the share charge here, and you should leave him out. No, you should leave him. Continue on them share charge, then you go ahead on them criminal party too, what the offense here. I'm not thinking here, Minister. What you are thinking on that? Thank you.
Thank you. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honiara for that question. In the scheme of things, if it were in terms of financial implication offences, then charges would be something that is appropriate. In this case, it's a different scheme of offences that apply here, and therefore inclusion of surcharges wouldn't be so appropriate. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Honourable MP for Central Honiara again.
I have interest number, Minister of Finance. Oh, I'm Minister. In time, I apply share charge too. Me, the Mstaka Imin lawyer should be attracting share charge here. People try to think people say, I'm saying that comment simply because, there seems to be excessive privileges that some of you may attract them to here. But anyway, coming back to this, I think, Minister, definitely, I think you need to really push on this one here and then apply to government assets because, they are the ones, that mostly have been overly, abused inside the system here. And as we are targeting over the public offices, others that are making the decisions are escaping, actions, allegations, and the blames on this. Thank you, sir. I think it's a good provision. Thank you.
Thank you. Thank you, Honourable MP for Central Honiara. Minister, you agree with the Honourable MP?
Thank you, Chairman. May I acknowledge comment below Chairman of the PAC. Thank you.
Thank you. And if there are no further comments, I'm going to move put the question. The question is that clause 119 as amended, stand part of the bill. Those in favour, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 119 as amended, therefore stands part of the bill. Again, clause 120, honourable members, there is an amendment proposed to this clause. The Minister, please move the amendment.
Thank you, Mr. Chairman. Sir, I move that clause 120 is amended at the maximum penalty by substituting 5,000 with 100,000 and 6 months to 10 years. Thank you. This one again, also have me harmonize with the section 273 of the Penal Code. Thank you.
Thank you, Honourable Minister. So, member wish, before I put the question, any member wish to comment on this amendment? If there is none, I'm going to put the question. And the question is that clause 120 is amended at the maximum penalty by substituting 5,000 with 100,000 and 6 months to 10 years. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 120 therefore stands amended accordingly. And before I put the question in respect of clause 120, does any member wish to comment on that clause as amended? Thank you. If there's none, I'm going to put the question. The question is that clause 120 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 120 as amended therefore stands part of the bill. Again, clause 121, there is a proposed amendment, and I call on the Minister to move the amendment.
Thank you once again, Mr. Chairman, sir. I move that clause 121 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. Again, this one, also harmonized with him, the Electoral Act of 2018, Section 127, and I'm also addressing now the recommendation of Bills and Legislation Committee, recommendation 65. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, any member wish to comment on this amendment? Thank you. If there is none, I'm going to move the question. The question is that clause 121 is amended at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 121 therefore stands amended accordingly. But before I put the question in respect of clause 121, does any member wish to comment on this clause as amended? Before I put the question. Thank you. I see none, and therefore I'm going to put a question. The question is that clause 121 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 121 as amended therefore stands part of the bill. Clause 122, again there is an amendment proposed to this clause, and the Minister, please you move the amendment.
Thank you, Mr. Chairman. I move that clause 122 is amended at the maximum penalty by substituting 5,000 with 100,000 and 6 months to 10 years. This one, again, the bill harmonized with Section 8 of the Whistleblowers Protection Act 2018, and also addressing recommendation 61 of the Bills and Legislation Committee recommendation.
Thank you, Honourable Minister. Honourable members, before I put the question, any member wish to comment on this amendment? Thank you. There is none. I'm going to put the question, and the question is that clause 122 is amended at the maximum penalty by substituting 5,000 with 100,000 and 6 months to 10 years. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 122 therefore stands part of the bill. Okay, the amendment has been, but before I put a question on the clause, does any member wish to comment on it as on the provision on the clause as amended? Thank you, Honourable MP for East Arare.
Thank you, Chair. Thank you, Minister. Just your ideas and interpretation around victimize. What now? What now, Ting Ting Lo? What is victimization? Or you say victimize lo here? What could be an example? Thank you.
Thank you, Honourable Minister.
Yes, thank you, Chairman. Probably one of the example of that one is maybe one fellow employee and provide him what false information or information where maybe lead to taking action against another employee. That could be one example of that. Thank you.
Thank you, Honourable Minister. Any further comments on that clause? First, let me put the question. The question is that clause 122 as amended stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 122 as amended, therefore stands part of the bill. Clause 123, again there is a proposed amendment, and I ask the Minister to move the amendment.
Thank you, Mr. Chairman, sir. I move that clause 123, subclause 2 is amended. A, at subclause 2, at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. And B, at subclause 4, at the maximum penalty by substituting 5,000 with 150,000 and 6 months to 15 years. The SONAMI also harmonized with Section 54 of the Anti-Corruption Act. With the Anti-Corruption Act, and also let me address him now, recommendation 65 of the Bills and Legislation Committee recommendation.
Thank you, Honourable Minister. Honourable members, before I put a question, does any member wish to comment on this amendment? Thank you. If there is none, let me put the question. The question is that clause 123(2) is amended. A, at subclause 2, at the maximum penalty by substituting 5,000 with 50,000 and 6 months to 5 years. And B, at subclause 4, at the maximum penalty by substituting 5,000 with 150,000 and 6 months to 15 years. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 123 therefore stands amended accordingly. Before I put the question in the respect of clause 123, does any member wish to comment on the clause as amended? Thank you, Honourable MP for East Arare.
Thank you, Chair. Just on the 123(2), must not disclose any information. Any now. So I'm just thinking about, there might be someone willing to write a book or something in the future about experience blogata, and that would help the nation too. Some pala leaders here. Be like you almost write them out the books too, yeah, and tell your stories. I was just thinking like any information might be too heavy, man. Stuck information there, they might be able to share, but maybe confidential or secret or something like that. And then we allow. I think what is needed. I think in terms of some of our leaders might want to write a book or something, and some might go around some issues that they'll be dealing with, including in their experiences as leaders in the national level. Just wanted to know whether we might be too restrictive by using any, and we might allow that space by using some other words. Thank you. Thank you, Chair.
Thank you, Honourable MP for East Are. In response, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Istarar, for that question. Here it applies to information, proprietary information that belongs to the Solomon Islands government. So any disclosure of any information you obtain during the course of your employment or discharge of your duty, you will be deemed to have committed this offense. Now, if you look at subsection 3, that one, you will also see that there are scenarios by which have not apply. Now, one of them is BEO is authorized to disclose the information by lawful direction given under this act or another act. So, if the custodian of this information is the Permanent Secretary or the Minister of Public Service, a person or something like writing book would have to write and seek that permission to do that. Then, if and that person got on the lawful authority for him, give him that permission, then once it's given, you're covered. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Honourable MP for East Are.
Thank you, and thank you to the AG for that. So I think generally, is it the understanding that the process would be that if you want to do something or write something, get that clearance, even you're a former minister, to get that clearance even from perhaps your office or otherwise before you even do that too, yeah? That could be the process as well. Thank you, Chair.
Thank you, Honourable Member. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP Istarar, for that question. Yes, that is a process. You probably, as the Constitution you say STC is the head of public service, so you probably would, the first place you'd write to is the Secretary to Cabinet for permission for that permission for that releasing of that information. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Just for the position of Parliament, the proceedings of Parliament are captured in Hansard, and Hansard is public information where you can access and look at the performance, debates, what members of Parliament said. If you're going to write about yourself, you visit Parliament, you have the right under the rules of the House. So they are kept in Hansard. Those are public information. So you don't need to seek the permission of the Speaker, I think. So for the Public Service Act. Okay, this one applies to this. Perhaps against the backdrop, you still have that, but under this restriction, perhaps the window is also open here. We revert to that arrangement by quoting your rights to access the records of Hansard. Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Just to elaborate further on that, now if you see 123 clause 2, and narrow down information there where you got access to during the course of carrying out that function under this act. So if that information you take in the performance of your duty below NARA Act, then it probably be covered under that act. Whereas for this one, what you do under this act and above, you have covered for this one. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments? If not, let me put the question. The question is that clause 123 as amended stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 123 as amended, therefore, stand part of the bill. Clause 124. Does any member wish to comment on this clause before I put the question? Clause 124. Thank you. If there is none, let me put the question, and the question is that clause 124 stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 124 therefore stands part of the bill. Clause 125. Any member wish to comment on this clause before I put the question? 125. If there is none, I'm going to put the question. The question is that clause 125 stands part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 125 therefore stands part of the bill. Clause 126, honourable members, there is a proposed amendment to this clause as appeared in the business paper number 63, and let me ask the honourable minister to move the amendment. Honourable Minister.
Thank you, Mr. Chairman. I move that in clause 126 2B, substitute N2 with N2. Thank you.
Thank you, Honourable Minister. Just elaborate on that.
Thank you. Just for making clarity in the law that for subclause. Thank you.
Thank you, honourable members. If I put a question, does any member wish to comment on this amendment? Thank you. If there is none, let me put a question. The question is that in clause 126 2B, substitute and A2 with and 2. Those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 126 therefore stands amended accordingly. But before I put the question in respect of that clause, does any member wish to comment on this clause as amended? Thank you, Honourable MP for East Arare.
Thank you, Chair. 126, 2B. I think that's the one that's been amended. Thank you.
Thank you. Any further comments on that clause as amended? If not, I'm going to put a question. The question is that clause 126 as amended stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 126 as amended therefore stands part of the bill. Clause 127. Any member wish to comment on this clause before I put the question? 127. Thank you. If there is none, let me put the question, and the question is that clause 127 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 127 therefore stands part of the bill. Clause 128. Does any member wish to comment on this clause before I put the question? Thank you, Honourable MP for East Choiseul.
Thank you, Mr. Chairman. Just to refer the government to the recommendations made by the Bills and Legislation Committee for recommendations number 66. It recommends that clause 128 be amended to clearly state that protection applies only to actions taken in good faith under the Act, so that officers can report misconduct or cooperate without fear while being held accountable for any actions outside these rules. Or Nottingham law, government law that one, and is it accommodated in the bill?
Thank you, Honourable Minister.
Thank you, Chairman. Minority comment block, MP for East Choiseul. With regards to the recommendation 6, yeah. Thank you.
Thank you, Honourable Minister. Honourable MP for East Choiseul.
Sorry, Mr. Chairman, I'm good now. How government's response to recommendation number 66, Mr. Chairman.
Thank you, Honourable MP for East Choiseul. Honourable Attorney General.
Thank you, Mr. Chairman, thank you, MP, for his choice for this question. 128 is a reflection of the Whistleblowers Protection Act. Whatever is done is protected under that, so him just a reflection of that and mirror of that. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Any further comments on that clause? Honourable MP for Central Honiara.
So that's 129, is it? Oh, 128? Oh, thank you.
Clause 128. Okay, if there are no further comments on that clause, let me put a question. The question is that clause 128 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 128 therefore stands part of the bill. Clause 129. There is an amendment proposed to this clause as appeared in the provisional of the paper, and I will ask the Honourable Minister to move the amendment.
Thank you, Mr. Chairman. I move that clause 129 is amended as follows. A, in subclause 1, by substituting for first mentioned with from. B, in subclause 2, substitute an employee with subject to the Constitution an employee. Thank you. Again, this one and more. Yeah, yes. Again, this one I'm just for improvement for because I think there's an issue with him. Constitution section 49B, having disqualify elections as member of parliament, those who hold office or inacting in any public office. However, section 145, subsection 2 of the Constitution, exempting public officers who is on leave of absence and an officer from the government of Honiara City Council as not holding public office. Thus, the bill has to account for this in clause 129, 2, which states that subject to the Constitution, a public officer wishing to contest an election for parliament or provincial government and Honiara City Council must resign from the public office. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable MP, for his choice.
Thank you. The bill, the committee, I'm also making my recommendations about this one, and I think probably Minister address him come and that one is for well, I think for the what he reading said that now the committee recommends that the minister conduct a comprehensive legal research on clause 129 to determine whether a constitutional amendment or alternative mechanism is needed, ensuring that public officers on unpaid leave or in other exceptional circumstances can stand for election without conflicting the Constitution or existing legislation. So I don't know, maybe the Minister may explain him, come but not give him good, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Let me ask him 84. Let me clarify that one.
Thank you, Honourable Attorney General.
Clause 129.
Thank you.
I don't know whether, I think the scheme of arrangements, lawyers, that the person must resign, yeah? It's that clear, I must resign from contest, yeah? I think what the Bills and Legislation Committee and raise him come, was this as money, unpaid leave, or same, I mean, sort of contest too. run foul with the Constitution or something, or some amendments need to be made. If this is a good suggestion, then you need to amend it. They want to even run sort of people who are public service to some good people contest and about to lose about the Kogona. Which about contest and about to lose or come back with public service or something on paid leave. I think that can what's very scenarios and I'll look at here, Mr. Chairman.
Thank you, Honourable Member for East Choiseul, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for East Choiseul, for that suggestion and comment, and also too for the recommendations by BLT. We do note the concerns raised. However, I think I don't think there is a constitutional breach in this. There's a number of issues why that is not, why I think it's not a constitutional breach. However, if, it'd be better if that would be in a legal format now, so a legal advice on that, rather than just on the floor of Parliament and just off-cuff remarks. But as it is, we did. I think Electoral Act him also require something also too similar to that. And it's the same thing at the time. There was an advice given that it was no interfere, no contravening constitution. I note the comments Chairman LRC making. There could be a conflict as opposed to as opposed to a contravention. That's another something to wait by need for look him. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General, Honourable Minister.
Thank you. So I'm glad for acknowledging comment law MP for East Choiseul. You are right to say in fact the policy intention on this one is to harmonise the provision of the political hierarchy of public officers with the Constitution. So this amendment here I have made for accommodating recommendation 67 law based on this committee and ensuring the harmonization of clause 129 within the Constitution. Thank you.
Thank you, Honourable Minister. Just for the information of the committee, just recording where this resignation started. I think the MP for East Choiseul would know. It started on the 5th Parliament, election for the 5th Parliament in 1993. Before that, the 4th Parliament and back to the 1st Parliament in 1989, public officers were not required to resign from their position until the 5th Parliament elections in 1993. Henceforth, after that, it continues until the 12th Parliament now. So the issue is, if we're going to retract this, the issue is that it's been there for over those years. Why suddenly it has come through? It is the right of the individuals to stand by virtue of their qualification for as a candidate, to be a candidate in the elections. So those are the issues too. But this is the background why the changes over those years since the 5th Parliament in 1993. And the Minister, MP for East Choiseul and the Speaker were victims of that requirement in 1993. Thank you. Just for that, as a background to this whole exercise, which the recommendation is now what is to deny our right as individuals, still qualify under the provisions to be a candidate at the elections. Where did we earn that become victim of an issue where we were entitled under the provisions of the Electoral Act to be candidates? So those are the issues. Just want to share with you because we were part of that exercise over those years. Thank you. And okay. Honorable MP for Central Honiara.
Yes. Well, thank you for that. Yeah, all of us were in that same situation. One of the qualifying factors to be eligible to contest is that you have to be a citizen and a registered voter. So a public officer qualifies in that way. He is a citizen and a registered voter as well too. So my question is to the AG, where in particular in the Constitution it's restrict or ban a public officer who is a citizen and a registered voter to stand as a candidate. That's his constitutional right. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr.
Who is a public officer, a citizen, and a registered voter. Where in the Constitution it bans him to be a political candidate. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara for that question. Just bear with me. Okay, Section 49 of the Constitution MC, you shall not be qualified for election as a member of Parliament if you are holding any public office. Okay, so Section 144. Means an office, public office means an office of emolument in the public service. So by virtue of that, public officers, if you want to contest, you must not be a public officer. You must not be paid as a public, in the service, what the word now is an office of emolument in the public service, which Constitution and Museum. So you would have to resign from your job in the public service, and after that, then you shall be qualified to be elected as an MP. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable MP for East Harare.
Thank you, Chair. And going by your history in terms of what you just mentioned, with which you were a victim, was this Section 49 already in effect at that time in '93 or before '93? And why did the Fifth Parliament make a decision not to allow public office holders to have to resign to contest? You have perked the interest of some of us current members in terms of your brief history on this particular issue. So just wanted to ask a question, whether this Section 49 with the reference was there already before '93 and how it was applied before. What was the difference between then and now, or post '93? Thank you.
Thank you. The independence order was passed in 1978, so this was already in application. So in fact, there were elections being carried out in Parliament 1, 2, 3, and 4 against the requirements of the Constitution. So it was only brought to the attention for the purpose of the fifth elections or fifth Parliament beginning in 1993. Before that, the provision was already there, but it was not strictly applied. So public officers were going to the elections, coming back. If they lose the elections, they go straight back and get back to their posts. Those were prior to 1993. So as I said, the law, the constitution, the provision was already there, but it was not applied. I cannot say why not, because I was not in a system to deal with that, but I only accepted it to become a victim. Thank you. Honorable.
Thank you, sir.
Yes,
Sir,
Chair.
perhaps defining hold or is acting would somehow make some difference in interpreting that position, the situation. Will taking a leave means and not paid, unpaid leave, is it? Yeah, unpaid leave will mean that you were not remunerated for that period, and therefore you are not holding the office. What's your view on that, AG? Because the requirement here says that either you hold or is acting, and if you go to the definition of public office here, that you are on what here? What did it change? Emolument, yeah. You are on, an office of emolument in the public service. But for that period, you were not paid. You were not awarded an emolument for that period. So, in the term used there is hold or acting, like that, yeah? What's your view on that, Attorney General? Thank you.
Thank you, Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara, for that question. Regardless of you being on unpaid leave, you are tagged to that position in public service. So by virtue of you being in that position, although you're not discharging any function, at that point in time, you're not getting paid for that, you are actually in that service of your public service in that position. And with that, you are captured under that exclusion. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable MP for East Arare.
Thank you, Chair. Thank you, AG. This act, as we have already seen, doesn't cover teaching. Yeah, Teachers Commission is not covered. So is it the case then that they don't have to resign to contest? Doesn't this cover them as well, or not? Or I think there's an agreement somewhere that they can continue or leave without pay, or they have to resign as well. Thank you.
Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for for that question. No, they are also required to resign. I recall the last election, a number of teachers were at the Electoral Commission requiring confirmation without have to resign before contesting, and I think advice given was they have to resign as well for contest. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable MP for East Arare.
Thank you, AG, for that. An employee, as we have here, as this refers to, is actually defined here already in this particular bill. But if I'm correct, it doesn't cover teachers. Somehow teachers is not covered here, as we've already come through. So this particular section doesn't apply to them, or they have another part of the law, perhaps differently, that applies to them, that also covers their need for resignation, or do teachers don't have to resign? Perhaps they can just go and leave. Just asking for some clarity, Chair. Thanks.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for his Unfortunately, Minister assisting me now. But I know I recall there's been advice given on that issue last election, whereby a number of teachers say for contest and they had to resign. And also too, I think not the last one, past previous one, I think one teacher was disqualified for not resigning in time. So it was too young. Law, I think General Constituency, Law West and Province. I think they're nothing. Yeah, so that's, I mean, the exact provisions in application law, I don't have it with me now, but I can recall that was one of the contention at the time, and it was held. Advice given was on that note now. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. There are further comments or questions on the proposed amendment? If not, I'm going to put that question. And the question is that clause 129 as amended is amended as follows. A, in subclause 1 by substituting for, first mentioned with from, and B, in subclause 2, substitute an employee with subject to the Constitution, an employee, and all those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Before I put the question in respect of this clause, does any member wish to comment on that clause as amended? Thank you, Honourable MP for Are.
Thank you, Chair. And I think just continuation from what we have just been deliberating on before we approved the amendment. Perhaps the Minister can, as I mentioned in my debate, perhaps the Minister can think about the idea of resignations or leave without pay for public servants who are women, to allow them to perhaps contest, to allow an increase in candidacy, maybe from the public service women, many of whom might want to also contest. And we know that in the policy of governments past, perhaps even present, the idea to try and encourage women in the election processes. Maybe we can see that holistically as well. So just a suggestion perhaps for the policy issue, perhaps for the Minister to perhaps consider it more. Thank you.
Thank you, Chairman. Thank you, MP for Estarare. Me take note of those comments. Thank you.
Thank you, Honourable Speaker. Any further comments? Otherwise, I'm going to put the question. The question is that clause 129 as amended stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 129 as amended, therefore stands part of the bill. Clause 130, does any member wish to comment on this clause before I put a question? Clause 130. Thank you, Honourable
Chair.
Chair of PAC.
Chair, I was a bit late in making a comment law 129, but perhaps in the meaning of the commencement law of this fella, or repealing of this, or the can I ask this question on the interpretation on the AG? Maybe you shall look at this one, yeah. Section 145, subsection 2 of the Constitution, where it says, for these purposes of the Commission, a Constitution, a person shall not be treated as holding or acting in a public office by reason only that he, what can you interpret him that one for me, please? Before, I mean, in the context of how now by this act will commence. Me find him go become Kasim with that one. I have always been confused with that particular provision. Thank you, Chair.
Thank you, Honourable Chair of PSC. Just not point of order, but perhaps we are on 130, close 130 at the moment. The question you raised, by definition, where does it fit into close 130 here?
Well, say, I try to generally just ask for your leave to have it interpreted in the way commencement of this act, like that, yeah? So you look at everything now, yeah? Including 129 here, yeah? Including that section 129. And then perhaps for you, just for clearing come number mind law, MP law Central Honiara, law section 145, subsection 2A, law holding office, and what's your interpretation on that one? Thank you, sir.
Thank you, Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara. There is an advice that was tendered on that, where at the moment we no have access to and we no have recall back to what the provisions was used and how it was interpreted to disqualify public officers. But suffice to say that the advice did go and say that public officers had to resign. Just need to refresh my memory, but that means I have to go back digging more through what that advice is. Yeah. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Any further questions on that clause 130? If not, I'm going to put a question, and the question is that clause 130. For those in favor, please. For those clause 130. Those in favor, please say aye. Aye. Those against, say no. I think the ayes have it. Ayes have it. Clause 130, therefore, stand part of the bill. Clause 131. Again, any comments on that clause before I put the question? Clause 131, sorry. If there is none, let me put the question. The question is that clause 131, sorry, Honorable MP for Isarare.
Thank you,
The
Chair.
screen in front of me makes me cannot see any of you sitting
Bruna,
at the back.
yes,
Thank you.
TV block muito wala eh. Thank you, Chair. Just quickly, Noma, I think it's fair to say that the new bill sets out offences, which perhaps was not there in the older original Public Service Act, and the idea that a lot of these offences, well, all of them, require prosecution in terms of investigations and that. So, in terms of this new act that's coming in now, repealing the old one, policy blow you law minister in terms of training more or what blow you fala. I think Attorney General is already doing something similar with other acts. Where Garam now, it seems to be the practice now that they may put them offences inside law acts this time to make sure that capacity law ministry and strengthen law side law this fella particular issue, particularly with offences and its particular connection with criminal law, prosecution and police investigations. That one no more. I think Minister by put them some other powerful people inside the office, him or the ministry itself, so that we make sure that what we pass here and the compliance that will be coming in is going to be effectively enforced. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for this. So the policy intention for this act is for increasing our work managers and especially the professional standard unit, what are able for taking one of the work where needed as per demand. Thank you.
Thank you, Honourable MP for Central Honiara.
Thank you, sir. This clause here, we are repealing the Public Service Act. So as we are bidding farewell to the 1988, 1989 Act here, me just like for just pay tribute a little bit no more the way some of the words in that act have been drafted, but somehow, no apply law here. For instance, where it says, notwithstanding the provisions of any other law, the minister after him consulting the commissioner, law here, some of the words we use you just go straight no and say, minister by doing this one, then by him go consult him, was man. Sorry, a little bit too low, some story inside law, this law, you mean miss by you miss him now, what kind of word, kind phrase, sir. So, me like to ask him, no, my AG, why did we depart from some of those phrases as we bid farewell to this law? I mean, I'm all-time kind of waiting, but I just want to say that a little bit on no more for farewell, no more, because this provision and basically say, you go bury money now, bro. Find many coffin today, no more, you go bury now. So, and remember, these laws are like human beings, no more. I mean, they are there. I'm helping you, Miron. I'm helping you, Miron, for do our job. It's done a great job over the last how many years? 30 years. But this time you mean by Berem now, so what was it? Or changes in time, language may change, or what is it? But these are some very beautiful phrases, yeah. I must say. So, you know, AG, what now? Thinking lo use, so sometimes you missing hotel or drafting. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Maybe me not catching no question inside Lord statement. I thought it was farewelling, not so me no hearing, but not just question in the midst of the statement. Because I give the MP for Central Nera can repeat the question. Thank you.
No, me just like for some put him in a joking way, no, or something. Yeah? I mean, I was just saying that. Clause 131, yeah, and basically say that we'll have to bid farewell to this law, yeah, so to speak. You may finish him now, yeah. This one by no apply now, but some are very important, phrases where and writing, drafting, where what are doing law here, yeah. You may know seems to caption inside law this new bill. I'll give you one. Suppose you look law subsection 1 and law section 4, for instance, that's going a little bit further. Section 3, law all act here. It says, notwithstanding the provisions of any other law, minister may, after consulting the commission, seems to give the supremacy to the commission, yeah? But law here, yeah. The new one where Embarrass go straight now and say, no, you doing this one now, and then the commission you must do him also. This kind of so I'm no a little bit small comment with me like for make him. But the old 1988 and the Public Service Act, today this provision and throw you on finish now. You're gone. Emotion. But to you, AG, because you are the one heading the drafting, the choice of how you may draft in this our current legislation now that we are going to adopt it here and may have changed. Is that the reason why we have moved away from some of the phrases we have used law the old legislation here? Wow, thank you, sir.
Thank you, Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Nara, for those insights and questions. The style of drafting in our own laws reflect in the also the past way we use them all archaic legal phrases, words. Very lengthy, notwithstanding here and after what kind of Joseph now we just may do away with him those words and using plain simple English for drafting what laws blame and just to make him easier for the people who by using laws understanding too, rather than have to wait for a legal person for him interpreting our laws. So it's about plain in language, using laws in plain, simple English language. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. And I think just for complimenting what you said, in law, when you say you're finished, the law is finished, that's the word used, repeal. So it's order. We are already farewelling it. Time to leave him up finished. That's why the language in law used there is repeal. Cannot say any other words to it. I mean, you were just repeating all the legal questions, legal language is a legal language. Thank you. And with that comment, let me put a question. The question is that clause 131 stand part of the bill. Those in favor, please say aye. Those against, say no. I think the ayes have it. Ayes have it. Clause 131. Therefore, stands part of the bill. Clause 132. Any comments on that clause before I put a question? Clause 132. Thank you, Honourable MP for East Are.
Thank you. Just on the general orders, 1985, 2016, just for information, Numa, we have two general orders, or what the times where it come into force? Normally here it's just one, but it came into force in these two different dates. Thank you.
Thank you, Honourable Minister. My apologies. I think, first of all, before we move that, there's a proposed amendment to this clause. Unfortunately, we did not ask the minister. So, Minister, there's an amendment. Can you move that amendment to this clause before we delve into that? Thank you, Honourable Minister.
Thank you, Chairman. Vice Premier, need for clear 20 minutes for stuck water. Thank you, Mr. Chairman. Sir, I move that after clause 132, the following apply. A new clause 133 is inserted after clause 132 as follows. 133 subsidiary laws saved. The following subsidiary laws continue to effect until and unless they are amended, revoked, or substituted under the Act. A, Public Service Permanent Secretary, Terms and Conditions, Rules 2024. B, Terms and Conditions of Service, Chairman of Law Reform Commission, Rules 2013. Public Service, C, Public Service Special Temporary Employees, Rule 2005. D, Public Service Government Properties, Vehicles and Plants, Rule 1992. E, Public Service Overseas Service, Rules 1994. And F, Delegation of Powers, LN number 17 of 2011. B, current clause 133 becomes clause 134, and the current clause 134 becomes clause 135. Thank you.
Thank you, Honourable Minister. This here. Before I put the question, does any member wish to comment on this amendment? Thank you, Honourable MP for his Arare.
Thank you, Chair. I think we take it in good faith that all these amendments are going to be looked after and covered by the Attorney General's office. We'll go through each one by too much now, but I think we just take it in good faith that all of these transitional and savings issues will be done in proper justice and manner, so that we have done our bit. in terms of looking at them, and thank you, Minister, for introducing them.
Thank you. Any further comments on this amendment? Otherwise, let me put the question. The question is that after clause 32, the following apply. A new clause 133 is inserted after clause 132 as follows. 133 subsidiary laws say the following subsidiary laws continue in effect until and unless they are amended, revoked, or substituted under the Act. A. Public Service Permanent Secretary Terms and Conditions Rules 2024. Terms and Conditions of Service, Chairman of Law Reform Commission, Rules 2013. Public Service Special Temporary Employees, Rules 2005. Public Service Government Properties, Vehicles, Plants, Rules 1992. E. Public Service Overseas Service Rules 1994. F. Delegation of Powers, legal notice number 17 of 2011. B. The current clause 133 becomes clause 134, and the current clause 134 becomes clause 135. All those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. A new clause 133 is therefore inserted accordingly. Before I put the question in respect of clause 133, does any member wish to comment on this clause as amended? Thank you. If there is none, let me put the question. The question is that clause 133 as amended stand part of the bill. All those in favor, please say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 133 as amended, therefore, stands part of the bill. Clause 134, does any member wish to comment on this clause before I put the question? Thank you, Honourable MP for Central Honiara.
Yes, maybe Minister for yung kamno any particular example normal where subclause 2A will be treated as being proposed in your bill, or the position that Babaya would have the same effect immediately after the. Do you have an example of it?
Thank you, Honourable Minister.
Sorry, point of order. Sorry, Chair, point of order. I think my original question in terms of the general orders before we went through the amendments on 132 and the new 133.
That's correct. I think the question were raised in regards to clause 132, which has those specific references to those general orders. Yeah, Honourable Minister.
Thank you, Chairman. So the 1985 general orders now mean the original one, but it has been amended over the years. Thank you.
Thank you, Honourable Minister. Any further comments on the clause as amended? Honourable MP for East Arare.
Sorry, just thank you for the Minister. So just to be clear, it appears here that 185 and then 1985 and there's another 2006, but effectively there's only one general order. Thank you.
Thank you. Honourable Minister.
Thank you, Chairman. Yes, exactly. Thank you.
Thank you.
Thank you, Chairman. With regards to question below, MP below, Mr. Honera, every public servant system me employed under the the current act here. So once this one pass, but everyone ever continue no matter the new act number 2 here. Thank you.
Thank you, Honourable Minister. We will close 134. Any comments on that clause before I put the question? Okay, if there is none, let me put the question. Question is that clause 134 stand part of the bill. Those in favour say aye. Aye. I think the ayes have it. Ayes have it. Clause 134 stands part of the bill. Clause 135 and 135. Any comments on that clause before I put the question? Thank you. If there is none, let me put the question. The question is that clause 135 stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. Clause 135, who stands part of the bill. Clause 136, honourable members, there is a proposed amendment appeared in the notice business, provisional business paper. And let me ask the honourable minister to move the amendment.
Thank you, Chairman. Sir, I move that a new clause 136 is inserted after clause 135. 136 consequential amendments. 1. The Honiara City Act 1999 is amended in section 12 by substituting paragraph E with a new paragraph as follows. E. He holds or is acting in any public office or is an employee of the City Council. B. The Provincial Assemblies and Honiara City Council Electoral Act 2023 is amended in section 11(1) by substituting paragraph E with a new paragraph as follows. E. Holds or is acting in any public office or is an employee of City Council or. The policy intention by this one is to specify other laws that are affected by the means of consequential amendment in respect of passing of this bill. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable MP for East Areare.
Thank you, Chair. And again, just to restate what I said earlier with regards to the new introduction here of these amendments and the new clause, that everything is done in order, that we have it in good faith, that the drafting team and the ministry have gone through all that is needed to be done in terms of the consequential effects of this new act coming into force. So we put our trust to the AG and the ministry in terms of all of these consequential amendments. My only question is, Hembara last one, last consequential amendment, no good. You me second time, but nara clause coming more for yet another consequential amendment. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for Israel. Yes, as far as we're concerned, I think just for now, the only amendment, consequential amendment that is required. Thank you.
Thank you, Honourable Minister. Any further comments on that clause? If there is none, let me put the question. The question is that a new clause 136 is inserted after clause 135. Clause 136, consequential amendments. Number 1, the Honiara City Act 1999 is amended in section 12 by substituting paragraph E with a new paragraph as follows. E, he holds or is acting in any public office or is an employee of the City Council. 2, the Provincial Assemblies and Honiara City Council Electoral Act 2023 is amended in section 11(1) by substituting paragraph E with a new paragraph as follows. E holds or is acting in any public office or is an employee of the City Council or full stop. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 136 therefore inserted accordingly. But before I put a question in respect of clause 136, any member wish to comment on this clause as amended? Thank you. I see none, and therefore I will put the question. The question is that clause 136 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 136 as amended, therefore stands part of the bill. Now, honourable members, I will recall that on Wednesday, clause 17 was suspended from further consideration and voting. We will go back to clause 17 on page 11. Please make a reference to that because honourable members, the minister had proposed amendments to that clause. Honourable members, before I put the question, does any member wish to comment on this amendment? You recall, Honourable Minister, that proposed amendment to clause 17.
Sorry, Chairman, we're not getting clearly what now you like him.
Sorry, Honourable Minister.
Thank you, Chairman. One, in clause 6, other definition of transfer, insert the following. Trustee principle is the overarching public service principle as set out in section 17.1. 2, in clause 76.6, delete may at the start of both paragraph A and B. 3, in clause 83, renumber subclause 3 as subclause 2.
Thank you, Honourable Minister. I will put the question. The question is that clause 17 is amended. In A, at the heading, substitute public with trustees and public. And B, inserting a new subclause 1 as follows. The trustees principle is the overarching principle that public officers hold their positions of authority and responsibility as trustees of the people and must therefore act with integrity, impartiality, fairness, and accountability, and exercise their powers and duties solely for the benefit of the nation and its citizens. And C, numbering the provisions as sub-clause 1 and sub-clause 2. All those in favor say aye. All those against say no. I think the ayes have it. The ayes have it. Clause 17 therefore stands amended accordingly. But before I put the question in respect of clause 17, does any member wish to comment on that clause as amended? If there is none, let me put the question. And the question is that clause 17 as amended stand part of the bill. All those in favor say aye. All those against say no. I think the ayes have it. The ayes have it. Clause 17 as amended therefore stands part of the bill. Honourable members, that concludes our proceedings on this bill. And the committee is now dissolved, and the minister in charge of the bill will report to Parliament when the House resumes. Thank you. Parliament is resumed. Minister, please.
Thank you, Mr. Speaker, sir. Thank you for allowing me for making just concluding remarks following the bill going through the debate and also the committee. I'd certainly like for sincerely thanking every honourable colleagues for your contributions and constructive participation along with suggestions and valuable contributions so you make it to the debate and the stage, committee stage deliberations. The government through the Ministry of Public Service, I'm deeply appreciating the level of engagement, collaboration and support shown throughout the process of developing and finalizing now this landmark legislation. Mr. Speaker, I also wish to record my deep appreciation to the Bills and Legislation Committee Mr. Speaker, sir, I wish to report that the Public Service Bill 2025 has passed through the Committee of the Whole House with amendments.
Honourable Minister reports due consideration of the bill by the Committee of the Whole House with amendments. Public Service Bill 2025 is now deemed to be set down for third reading. Now I understand the Minister wishes to table a list of corrections under Standing Order 58.2 before we proceed to the third reading of the bill. Honourable Minister, please.
Thank you, Mr. Speaker, sir. By now, members should have a list containing the typing error within the bill, which identifies the error and describes how this will be corrected. Sir, I table the list for the Parliament's record.
Thank you, Honourable Minister. Honourable members, the House has been duly informed of the corrections that will be made to the bill under Standing Order 58.2. This correction will be made to the bill according to the table before it is sent to His Excellency, the Governor-General, for his assent. We will proceed immediately to the third reading of the bill.
Bills, third reading, Public Service Bill 2025.
Thank you, Honourable Minister, please.
Medium script, maybe. Thank you, Mr. Speaker. Sir, I move that the Public Service Bill 2025 be now read the third time and do pass.
Thank you, Honourable Minister. Honourable members, it is proposed that the Public Service Bill 2025 be now read a third time and do pass. Does any member wish to contribute to debate on the motion before I put the question? Thank you, Honourable MP, for his choice.
The bill with amendments, Mr. Speaker.
Thank you. Noted that the proposed Public Service 2025 bill with amendments. That's where you're coming from. Okay. It will capture that on the record with amendments. Be now read a third time. Does any member wish to comment on the debate on the motion? And that's where his choice MP is coming from, contributing to debate on the motion that has been moved by the Minister for Public Service. Thank you. With that note, I will now put the question. The question is that Public Service Bill 2025 as amended be now read a third time and do pass. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. The motion is therefore passed. Thank you. Let us move on to our next item of business. Thank you, honourable members. With your indulgence, I will suspend the proceedings of Parliament and will resume very shortly at 2:30 with your indulgence, and then of course from there we move on to the next item of business and by the Prime Minister. So on that note, let me suspend Parliament and we resume at 2:30.